Yeah. I'm setting aside the interference of the MLA MPs in the transfer matter. And I have just discussed the nature of the letter dated 13-5, and I have held that it is subsumed in a 14-5 letter, orders, transfer guidelines. Well, number one. Number two, even otherwise, it is incompetent. So I have excluded complete interference of MLAs and MPs in the matters of transfer of teachers. I have referred to Shilpi Bose, which you backed upon. Shilpi Bose involved executive instructions and transfer of non-teachers. I have made one paragraph, difference between teachers and non-teachers. Teachers are very important to the country. It is they develop the next generation. Therefore, interference is not warranted. Then I have referred to section 146 of the Representation of People Act, which permits the Election Commission to draw teachers for the election work. Read with section 27 or 29 of Right to Education Act.
Yes.
Therefore, the nexus between politicians and teachers will be a deadly combination, which I don't want to permit. That way I have structured that. Then I have held the transfer guidelines are statutory in character, which also you said. But still I have said that you doubted that, this one, but I have treated it that way. When the law prescribes some procedure, the same has to be followed for doing the thing. Taylor versus Taylor. That I have stated. Then I have mentioned your argument that you pointed out. The 13-5 dies because of 14-5.
Yes.
That I have stated.
Yes.
Then I have mentioned about Karnataka judgment.
Yes.
Karnataka judgment referred to 2006 Supreme Court,
Yes.
which Lenkar quoted. There also it was not teachers. It was other than teachers. Therefore, the difference between these decisions is that these are teachers and they are non-teachers.
The engineer.
Engineer. It was engineer. That way, I have structured the judgment. Then I have held a normative procedure has to be followed. The committee itself should take a decision. Your argument that it is only one of the inputs I have treated separately in a paragraph, taking your name also. It did not happen that way. They were swayed away because MLA said, MP said.
No.
I have said that way.
Yes.
Yes, because there are orders with which Mr. Swain read. Yes. But the one sentence order. The MLA has recommended and therefore we are doing that. That I have referred in that. The other set of cases where mutual transfer. Where is the mutual request? Nothing is produced before us.
Yes.
And you have not filed the objection statement also. Counter is also not filed.
Not there.
Therefore, that I have stated. No counter is filed and nothing has been stated. Then the timelines have been violated.
Yes.
The timelines are prescribed by the statutory instrument. There is some wisdom in that because they have to, otherwise family will be disrupted. These things. That way, I have structured the judgment. And not only mutual transfer. You have said that since it is mutual transfer, you are not entitled to DA. It is salting the injury. Therefore, I said that is not permissible. Then I accepted both Lenka and G's argument that if already those have been relieved, they should be permitted to work there. But after the end of the academic year, within 1 week, they should be sent back to their parent department because students should not suffer that way. Wherever that has not happened, they will continue in the same post. Okay. I have also reserved liberty to take all decisions in the light of this decision.
Another thing I had raised that 73rd constitutional amendment empowers the panchayat to provide primary education. That's also raised. Sarpanch, the people's representatives.
That is enabling provisional leadership. Government should come up with a law. They never come up with a law leadership. That's
I have not read
that.
One line I will add that.
Yes.
That prerogative with the state government they can do, but they have not done leadership. That is enabling provisional leadership. That is.
ଆମର ସରପଞ୍ଚ ମାନେ ଏମଏଲଏ ରିପ୍ରେଜେଣ୍ଟେଟିଭ ସବୁ ସମ୍ବଳ ଦେଇପାରିବେନି ଦେଲେ
No, what is that panchayat?
Panchayat, so far as panchayats are concerned, my lord, it is not possible to ask all the sarpanchs to recommend about the teacher's performance.
No.
My lord, it is my submission, right? No, counsel, let me. My lord, they are suggesting the names of the teachers to the MLA and MPs because they are the representatives. The representatives of the local nature. And
how,
they are,
all right, I will treat that also.
Man.
How that will, they will say, this teacher we want. What
My
happens to the students of that?
they will maintain rationalization.
Huh?
That is what they.
That I have not touched.
Yes.
That I have left intact.
Yes.
That you are entitled to
rationalization.
do.
Yes. Rationalization.
That you are
etc.,
entitled to.
Rationalization, etc., etc. Whatever provisions or conditions.
Whatever is there.
Condition.
Barring MLAs.
There are some allegations against teachers.
Yes, you
That.
can take. I have kept everything open.
My lord, Lordship may reflect it in the judgment.
I can't reflect because if it is only allegation, anybody can make allegation against anybody.
No.
Yes.
It should be.
Therefore,
It should be.
inquiry into take it. I need not say anything about that. Otherwise, suppose if I do not want a particular teacher in particular school because he is very strict in maintaining the discipline and my child is not disciplined and at any time it goes to school, whether it goes to school or not, nobody
No,
knows.
after inquiry by the
That is always with you.
educational authorities.
Whichever authorities can do on normative basis, that then panchayat need not be treated at all if that is so.
Political vendetta will be.
What political?
But the panchayat lordship, in fact,
I-
so far the panchayat is concerned.
No, that question I am not taking.
Obliged.
You assisted, all of you assisted, even government advocate party was very well. They are doing well. I have said that one line I have said.
After your lordship's judgment,
I will,
it is hoped that the government will bring up another.
I do not
revival.
know. I don't have much hope on government's
No.
plans.
And transfer this, they will not come back.
Then I have said this way. Writ of certiorari issues quashing the impugned letter number so and so, and the impugned transfer orders as well. The writ of mandamus issues to continue the petitioners in the same places in which they were respectively working before the issuance of impugned transfer orders, subject to what has been stated in paragraph 4.7. 4.7 is wherever they have been relieved, working. They will come in the next academic. That. The writ of mandamus issues also issues to dispose of all departmental appeals, wherever appeals have been preferred, whether they are here or not.
Yes.
In the light of the judgment within an outer limit of 4 weeks.
Yes.
That we have done. Delay shall be viewed seriously. That we have said. And no cause. No cause. We have copy to be acted upon. Good case for appeal also. I no. Yeah.
Item 2. Item 2, lordship, perhaps comes it falls within the parameters of 4.7 for this contempt. Because he is already.
Number 2 is so does not survive for consideration
Oh,
because
lordship-
of this judgment.
For lordship, because of this judgment, a lordship, that particular para 4.7
4.7.
already relieved and then session lordship.
Lordship, government has also issued letter to the director, to the district education officer Cuttack to implement your lordship.
No, that question also will not arise because I have made an order. Where 4.7
Lordship.
right now. Learned counsel appearing for the complainant in all fairness submits that this complaint is liable to be disposed of in terms of the observations occurring in paragraph 4.7 of the judgment rendered this day in WP numbers so and so, so and so. First off, for ease of reference, comma, the said paragraph is reproduced. Next paragraph. In the above circumstances, the complaint is disposed of.
Item 3.
Item 3, it's a matter relating to RSCP.
RSCP.
Ashok.
Similar matters are pending.
Issue notice. AGA, Mr. G is requested to accept notice for OPs. All OPs?
All of this.
OPs. Call this matter along with WP number. Sorry.
Item 4.
Under the Orissa Development Authorities Act, so alleging illegal construction of the scheduled property on the complaint of the petitioner, the notice was Annex 3 was issued to the encroacher by the CMC, Cuttack Municipal Corporation, 2023. Next page 25. When it was not disposed of, the unauthorized case, UC case, so I approved this Hon'Ble code. This Hon'Ble code directed the Deputy Commissioner Enforcement to consider. They considered a stout construction. Again, the encroachers, my lord, trespassing my premises, started construction. Then I approached to the CMC, Deputy Commissioner, and Deputy Commissioner passed the order, page 57,
Saying.
same, stop the construction. Again, it is being carried out by UP number 7 and 8.
7 and 8.
7 and 8. So there is a provision of penal provision. There is a penal provision, 87 and 92 of the Act.
Under that, they have to take, authorities have to take action.
Take action.
Let them take action.
Yes, ma'am.
Let them. It is non-consideration of representation.
The non-consideration out. No, consideration, but not in proper perspective. Page 57. So enforcement squad visited the disputed site and stopped the construction work. It is observed.
Then you take notice.
Yes.
Issue notice. G is requested.
No, I will take only opposite
One.
but number 1.
1. 7 and 8.
One and one. Okay. 1. Emergent notice to the rest. Okay. Post immediately after service. Okay.
Item 5.
My lord, Commissioner, they have the special counsel.
In addition to taking usual steps, it is open to the petitioner to serve copies of the special counsel if any.
The CMC, Cuttack Municipal Corporation.
CMs.
Published.
Next.
Item 5.
As a similar order, your lordship has already passed the matter related to arrears salary matter. It's a corrected copy, my lord.
Have you served a copy on the other side?
Already the copy has been annexed under annexure.
Annexed also.
The only
Only the different column has to be changed.
My lord.
Date has to be changed.
no, my lord. The difference is, my lord, in that case, there were several petitioners, but in this case, there is one petitioner, my lord.
That makes no difference.
And the petitioner has already made a representation under annexure 1.
Consider that, Mr.
My lord, that may be reflected, my lord.
But why?
Because, my
What
lord,
applies to rest of the people applies to you also.
My
You are
lord,
in the same
I
page.
mean, that case, my lord, there were several petitioners. That is why your lordship directed to file fresh representation. But in this case, the
Only
representation
single-
has been filed, my lord.
Yes.
Item 6.
May I please your lordship?
Huh.
My lord, may I take your lordship to page 42?
Or 2.
42.
Huh.
My lord, may see, the FSSAI decided that the products with a brand name including ORS shall be withdrawn.
ORS means
Oral rehydration salts. That's a WHO formula, my lord. My lord, may see, it is at page 42. This is in respect of the order cited above. All such orders issued in the past regarding the usage of the term ORS along with brand names. In this regard, it has been decided that the aforementioned orders and any other order previously issued in this regard stands withdrawn. Now, my lord, what has been withdrawn is at page 45. May I take your lordship to page 45?
what they have withdrawn.
They have withdrawn. FBOs may use the earlier what they had decided by
Not a ORS formula as recommended.
you
by-
can use the ORS, but you will have to give a disclaimer that it is not a WHO formula.
There was once a judgment by Hyderabad Court, Andhra Pradesh High Court, which went to Supreme Court. Identical issue.
Yes, that was before this. I mean,
Before this.
yes, my lord. Now what has happened? Your lordship may see they allowed in page
Take
45.
notice.
My lord, there is a difficulty, my lord. What has happened in the meantime, I will just show. There is also a development which I have brought in by way of an affidavit. I was
Let notice go.
Yes, my lord, I was praying for an interim arrangement.
No.
Only see.
It will affect what?
No. I bow down, my lord. I'll just show what is my product. If it is not Accept to your lordship, your lordship may not pass an order.
Actually, affect-
I do not have a product where I have mentioned the ORS. That is what I am saying. In by garb of this order, this order did not prohibit ready to serve fruit beverages from being sold. I am.
Let us see. Nothing will happen. Immediately after service, we will call this matter. That day we will consider.
My lord, I have served all of them. Your lordship may allow me a short date.
Issue emergency notice. Mr. You appear for
I am appearing for opener 1 and 2.
your name and
Yes,
three.
Just
Senior panel counsel.
Yes.
Senior panel counsel appears for 1 and 2.
I have got 3, 4, 5.
Lenka is requested to accept notice for other respondents, all other respondents. First one. Counsel for the petitioner presses the application in IN number 5, so supported by affidavit for interim order. First one. The same shall be considered after the filing of objection statement by the other counter, by the other side. First one. Call this matter week after next. Yes.
Item 7.
Is a retired assistant teacher. He's praying for regularization of the period from 6/4/2002 to 8/9/2010. Identical teacher, the retired teacher.
Regularized.
My lord,
Identical person is regularized.
they have been regularized by the order of this honorable court, confirmed by the honorable apex court. I have given at page 45, your lordship. Same, he was appointed along with
Let
the.
them consider in the light of that.
My lord, I have already given at Annexure 6 series.
Representation is
Annexure
6 series.
6 series.
To be considered in the light of Annexure 5. your lordship.
Petitioner seeks regularization of his services in terms of representation dated 14/11/2022. A copy thereof awaits at Annexure 6. First, counsel for the petitioner submits that the case of the petitioner is identical to rest of the personnel whose services have been already regularized. And in that connection, full particulars are given in the representation itself, including the rulings. And therefore, this court should intervene in the matter. First, next paragraph. Learned AGA, Mr. Lenka, in his usual fairness, agrees to instruct OP number 1
Yes.
to look into the grievance of the petitioner as has been aired in the subject representation, keeping in view the decision of this court and of the apex court in
Your lordship, and the WBC OSC number 2640 of 2011,
that which are
Annexure 5.
that have been mentioned in the representation itself.
The connected matter is same, but the annexure is.
All contentions are to be kept open, says Mr. Lenka. First, details.
In connected matter, Annexure 7, not 6.
Annexure 7.
Item 8.
Actually, regarding the RSCB matter.
Policy, any information, documents from the side out. If they want any information, you furnish it. In that case, however, relation or
Oblige, lordship.
Item 8, RSCB matter, lordship has already disposed of this. We have already corrected.
Similar to item 3, and your lordship has issued notice.
no, petition itself is disposed of.
No,
It's a bit different. Where you have to consider in the light of Ashok Kumar Mohapatra.
the item 3 also Ashok Kumar Mahapatra, today's list. And your lordship has.
Then it ought to have been disposed of actually.
Your lordship.
In the light of our earlier order.
Yes. Item 3.
Item 3, who appeared? In fact, we need not have issued notice at all. The notice we could have issued, but counsel is here.
No.
Counsel is not here. Let it know.
Okay.
Not.
Item 9.
May I please, my lord? My lord, the prayer of the petitioner for UGC scale has been rejected, my lord.
Has been rejected.
My lord.
You take notice.
My lord.
Like the
Yes.
who are the parties?
All government parties.
No, Union of Government Functionaries. Lenka appears for 1 and 2. Mr. DSGI party appears for 3.
4.
4 also.
My lord,
3 and 4.
5 may be dispensed with. 5 is not.
Huh?
5 is from a party may be dispensed.
5 notice may be issued.
Not.
Why you made a part? You delete him. Do you delete?
Yeah.
Petitioner orally requests deletion of OP number 5 as not being necessary part 3 nor proper part 5. First, request is allowed subject to this. Petition to amend the constitution. Next.
Item 10.
May I please, Lord? The petitioner is in lecture on aided college and he prays for a direction to consider his
Petitioner group A.
yes, group A and a reader scale as per your lordship judgment in the Loknath Vera case.
Let them consider that in
Yes.
the light of that.
Yes, I have also mentioned in my
In the
representation
representation annexer
8.
huh?
Annexure 8 at page
Petition there reads as that.
26.
First, counsel for the petitioner draws attention of the court to the representation dated 25/2025, wherein the last paragraph reads as follows. First one. Next paragraph. Counsel for the petitioner submits that the authorities are not taking the decision without intervention of courts nowadays, and therefore intervention is eminently warranted. First one. There is truth in this. There is a ring of truth in this submission. Next paragraph. Mr. Lenka, appearing for OPs, assures the court that he would instruct the OP numbers 1 and OP number 1 to look into the grievance of the petitioner in the light of the decision cited, if all contentions are kept open and a timeline is prescribed. First one. This the counsel for the petitioner bottoms with. First one. 8 weeks. Open to service. Next.
Item 11.
My dear lords, the petition is continuing as a CBK, my lord. The ST and SC Development Department, my lord. My lord, as per the government resolution, my lord, for extension of MSc benefit to the teachers, my lord, those have acquired 10 graduate qualification. Even though they are continuing in the post of a matrix teacher, but those who have acquired 10 graduate qualification, they shall be given the benefit of.
Where is your representation?
Representation not
Lordship,
they be
You
given
make representation and they will do.
my lord, what happened, my earlier, my lord, they approached on a tribunal, my lord. On a tribunal allowed the benefit, my lord. On the annexure of government passed order extending the benefit of RSCP to the teacher.
To others, sir.
Others.
No, you were not a party.
I am not a party.
You make a representation in terms of that, then they will consider.
My.
Yesterday, my lord has been pleased to dispose of similar type of my seniors.
That is serial number 19 yesterday case. my lord.
Yesterday's
Admission 19.
I will serial number.
yesterday's list.
My lord, the time may be stipulated, my lord.
Yes, yes, in all matters, I am stipulating that.
8 weeks, my lord.
Connected same, my.
Same.
Public.
Item 12.
Matter relates to re-engagement of
Yes, yes.
matter relates to re-engagement of junior teacher.
Re-engagement.
Re-engagement. What happened? 2018 Annexure 1 page 11, the petitioner was engaged as junior teacher. And he has continued, if issued against him,
Registered against him.
register against him, due to which the focus was he was arrested and sent to jail custody. And upon knowing this, and the collector issued a focus, why your service shall not be disengaged. He filed a focus, but however his service was disengaged in 2022.
What happened to that criminal case?
Criminal case he was acquitted.
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 Is it honorable acquittal? Or for want of evidence?
No, honorable acquittal.
Where is that? Show the judgment.
Yes.
Not honorable.
Page,
Not honorable acquittal.
yes.
But you dispensed it on the ground that he was involved in a criminal case.
Yes. Page 18 is the judgment.
High Court is asking questions to you. You are not supposed to interfere. Keep quiet. No, you did not hold any disciplinary point.
Not a schematic solution.
I am asking. you did not hold any disciplinary inquiry. You sent him out because a crime is registered on. Trial took place and he has been acquitted. Is it not?
Not.
And now if he is acquitted, you are going to take him back.
He has filed a representation before the.
You consider that representation.
That is annexed.
Take down.
41.
Petitioner's services were disengaged on the ground that a crime was registered against him, which after trial ended in acquittal. First of all, counsel for the petitioner submits that no disciplinary inquiry having been taken place, and now there being an acquittal order, the OPs are liable to take him back to the duty as before. First, in that connection, his client has already made a representation dated 14/7/2025, a copy whereof avails at Annexure 4 series. Seven series. Annexure 7 series. Counsel submits that if a direction is issued to consider the same in a time-bound way, his client would be satisfied. First, next paragraph. Learned ASC Mr. Sen opposes the petition, contending that undesirable persons like the petitioner cannot be retained in public service, and therefore he was removed on the registration of FIR against him. First, when the job market is open with scrupulous candidates, the officials cannot be directed to choose the unscrupulous ones. First, having so contended, he agrees to instruct OP number 2.
OP number 2.
To look into the grievance of the petitioner in a time-bound way if all the contentions are kept open. First, with this proposal, counsel for the petitioner is also agreeable. Next paragraph. Within 6 weeks.
Not 8 weeks.
Why 8 weeks? What is there? There is no Keswananda involved here. Yes.
Yes, another ballot.
Yeah, all contentions are kept open. Open to solicit information.
He has provided opportunity, my lord.
No?
He has provided before.
What opportunity? Now he has been acquitted. Yes.
Item 13.
Item 13 is similar to item 12, Your Lordship. In this case, the petitioner is the teacher. He is involved in a criminal cases. A FIR has been registered against him. And after thorough trial, Your Lordship, he has been acquitted by the Land Trial Court in 2024. Honorable acquittal is there.
How will you read honorable acquittal?
Yes, Your Lordship, I am reading it.
How do you say it is honorable acquittal?
Reason being, Your Lord, para 13, on further perusal of the evidence, it is seen that PW35, who are the victims in this case, to supported the prosecution in their examination, but they denied prosecution story in their cross-examination, deposed that nothing was happened in them at the instance of accused. There is even about 8 months delay in lodging the FIR. No explanation has been put forth by the prosecution for such delay, for which the prosecution case become doubtful. In fact, subsequent para. In fact, I am the opinion the prosecution has failed to establish the case against the accused beyond all reasonable doubt, and the accused is found not guilty for offence under section so and so for the said charges of the CRPC. The accused is set at liberty forthwith, and his bail bond is discharged.
Where is honorable acquittal?
Your Lordship, PW3,
which is the decision which deals with honorable doctrine.
Your Lordship, 2023, Imtiaz Ahmad,
Ramlal versus
Ramlal, and Imtiaz subsequent, it has Imtiaz Ahmad Mallah versus State of Jammu Kashmir. Your Lordship.
You consider representation?
Lordship, may I pray, Your Lordship, let the State Council be directed to file the counter. Reason being, Your Lordship.
Let them take a decision.
Let them take a decision, Your Lord.
Petitioner's services were disengaged on the ground that he was involved in a criminal case, which eventually on trial ended in acquittal. First, counsel submits that it is a case of honorable acquittal in the light of P.V. Rudrappa versus State of Karnataka, and therefore the authorities are liable to take him back by reinstatement in service. First off. He also points out that a representation dated 29/2025 made in this regard, which remains unconsidered till date. First off. Lastly, he submits that the officials in this state do not take decisions on the representations at all unless mandated by the courts. And that is a pathetic situation. First off, there is some ring of truth. There is a ring of truth in this submission. Since such cases come on, this court is seeing day in and day out. Next paragraph. Learned ASC opposes the petition, contending that unscrupulous persons cannot be engaged as teachers, since teaching involves not only imparting of knowledge, but morals also, and therefore, court should not interfere. First. However, having said that, he agrees to instruct OP number 4 to look into the grievance of the petitioner as has been aired in the subject representation in a time week, if a timeline is prescribed, and all contentions are kept open. First, with this proposal, counsel for the petitioner, courts. First, the 8 weeks. Open to solicit, etc.
Grateful, Lord.
Next.
Item 40.
Which is the addition, P. Virudrappa ruling.
Virudrappa ruling, I
Yes, you should apply.
I have noted that 2023 itself, I have.
Beyond that, law has moved now. Yes.
I correct.
May I please, ma'am?
Yes.
The petitioner was appointed as a guest faculty on 29/6/2022, and while she was continuing, she submitted an application for maternity leave, grant of maternity leave, Annex 3, and subsequently returned from the leave when she submitted a joining report that was accepted, Annex 5, but the benefit was refused on the ground that since you are appointed as a guest faculty, the petitioner was appointed.
It's covered by my judgment. I did that judgment.
State of Orissa versus Srimati Anindita Mishra. Para 3.
Appeal is filed on this. We had even all others are also entitled. Whoever is having the womb,
my lord,
is entitled to that maternity benefit.
But here's the university is the
OPG, but two.
Okay.
University.
That's all. Issue.
The my lord dispose of directing them in view of the judgment.
Bring that university lawyer. Will issue short notice.
Short date.
Or we'll tell them to look into
in view of the judgment. In view of the judgment.
That's what. That's right. The short grievance of the petitioner is against the denial of benefit, maternity leave benefit, on the ground that she is. Now you can say he also such operations happening. She is a member of guest faculty. First off, counsel for the petitioner submits that a division bench of this court in state of Orissa versus Srimati Anindita Mishra has laid down the parameters within which applications for grant of such benefits are to be considered, and there being already such a representation dated 3/2/2025 at annexure, correct?
353.
Comma, his client would be satisfied if a direction is given for consideration of the same at the hands of the university. First off. Next paragraph. Notice Mr. ASC, Mr. Sen appears for OP number 1. And the notice to OP number 2 is dispensed in, since the prayer of the petitioner is innocuous, in the sense that he seeks an order to pass an order on the subject representation in the light of decision in Anindita Mishra Supra. First off. Next one. In the above circumstances, OP number 2 is directed to consider the subject representation of the petitioner within a period of 3 weeks. 3 weeks. First of all, contentions are kept in the light of
Judgment.
in the light of decision in Anindita Mishra Supra within 3 weeks. First of all, contentions are kept open to solicit petitioner to furnish a copy of the Anindita Mishra judgment to OP number 2 for it. You keep a copy of that with us. Maternity matters. If I say, or with that judgment. So. Yes.
May I please?
Item 15.
May I please?
Yes, sir. Register to send a copy of this order by speed post to the university.
But in this case, I have challenged the rejection order under Annexure 13. Here, what has happened? My lord, by facing regular process of selection, I was appointed as a reader in Sanskrit. That is under Annexure 6 at page 27. Your Lordship may kindly see Annexure 6 at page 27. After facing regular process of selection, I was engaged as reader. Although in the advertisement, there was no...
There is no department of Sanskrit at all.
No, my lord.
Last paragraph, page 44.
Page 44.
Yes.
My lord, they say that it has been transferred to the campus of North Orissa University. That is there. Earlier, my lord, I had approached this Honorable Court. This Honorable Court categorically directed...
Campus is part of the university.
Part of the university.
Take notice.
Yes.
Issue emergent. Which is that judgment?
My lord.
Where I held the campus is notionally extended territory of the university.
Yes, yes.
Just look into
this. Yes, I will.
Issue emergent notice to all OPs.
To all opposite parties.
Next.
Item 16.
May I please, Your Lordship? This is again challenging the NMMS scholarship.
Similar matters were
taken. The only difference is that here the petition was from Jagatsinghpur and the residential school has been started to Flint Lake.
Any interim order was granted in that?
Your Lordship, to appear in the examination, which is supposed to be held on 7th December 2025.
Same order we can print. Higher number to be different.
Your Lordship.
Two to four. One party.
Your Lordship.
ASG. The DFPI, Mr. Party request is also notice for one. ASC. Mr. Ray on request accepts notice for 2, 3 and 4. Same order. This IA of the order.
Item 17.
May I please, madam? My lord, the petitioner has retired in the month of June this year. Seeking retirement benefit, Your Lordship, this is covered by the judgment passed by the Honorable Court in Hemant Chotrai, this major judgment.
The representation is
given. Annexure 18. Before opposite part number 1.
Petitioner's representation dated 21/8/2025 at Annexure 8 series. Representations at Annexure 8 series raise a grievance as to
retirement,
sanctioning of terminal benefits. In the light of
Hemant Kumar Chotrai,
give that ruling. You have not mentioned that.
Well, that's what the accused judgment.
For such a big judgment.
Yes, it's a major judgment.
We'll give it back.
It is not mentioned in representation.
No, that's what I.
Then that also have to give, na?
Getting block grant.
What you can do is, this judgment is not big, only cost item is big. In the light, yeah, that only one page you can take and give it, no? In WPC 30103 of 2023, between
Hemant Kumar Chotra.
Hemant Kumar Chotra versus
State of Orissa.
State of Orissa. And other connected matters disposed of by a coordinate bench of this court-wide order dated 13/10/2023. Sorry, 12/1/2024. First off, he submits that if a direction is given to consider this representation in a time-bound way, in the light of said decision, justice should be met to his client. First off, with this proposal, Mr. AAC is agreeable, provided that all contentions are kept open. First off, in the above circumstances, petition is disposed of, directing consideration of the petitioner's subject representation within an outer limit of 6 weeks in the light of the coordinate bench decision supra. A copy whereof could be furnished by the petitioner to the jurisdictional authorities for perusal. First, all contentions.
Item 18.
May I please alone? Annexure 21, page 63 is the letter of the director. They have in the letter they have admitted that the petitioner has already made application online for opening permission.
Permission for
opening the high school.
Opening the high school.
My application.
Let him take notice. Let him take notice.
May I blame since they have admitted that online application has been received.
Let them take a decision on that.
Let take a decision. That will
is it under section 6 of the
Section 5.
The short grievance of the petitioner is as to the long pendency of his online application dated.
Well, they have not yet.
When did you upload it?
Well, they have not given the date, but in the letter dated 10/9/2023.
Online application made under section 5 of the Orissa Education Act 1969, seeking permission for the establishment of the school. High school. First off, counsel draws attention of the court to the endorsement issued by the deputy director.
Office of the director.
Director.
Director of secondary.
Deputy director dated 10/9/2025, which reflects pendency of petitioner's application for permission / recognition. First off,
serial number 21 of said letter.
Yes, at an exact 21.
Page 64.
Yes. Counsel submits that if a direction is issued to take a call on the subject application in a time-bound way and in accordance with law, justice to his client would be met. First off, with this proposal, learned ASC, Mr. Sen is also agreeable, provided that all contentions are kept open. First off, this is a happy development taking place in the Rich Court. Next paragraph. So, within 8 weeks, open to solicit information, document from the side of petitioner as a required for due consideration of so and so and so. In that guise, no delay shall be had. If delay is caused, at the next level of the legal battle, heavy cost may be imposed.
Item 19.
May please, Lordship. Lordship, it's a writ petition where we have prayed for the refund of the amount of 62 lakhs which was seized during an ED search, which happened in November last year.
November
last year, my lord, where our contention is, my lord, on the summons that they have given.
PMLA.
No, my lord, it was under FEMA.
The FEMA.
FEMA, so section 37 of FEMA. So, my lord, and IT Act, as your lordship knows, is applicable here. So, we say, my lord, within 30 days, we gave them a reasoning. We said that kindly refund. We also gave them a reminder. More than 12
What they say?
Well, no reply has been given.
Call your Mr. Pari so that who appears for the council, panel council.
My lord, we have already served notice.
Your lordship, I am appearing for the opposite party.
You take a call on the subject representation in a time-bound way. Why can't you keep it like this? It is his money.
I will seek instruction to that effect and I'll get back.
Issue notice, learned senior panel counsel appearing for ED.
Copy has already been served, man.
Seeks a short accommodation to come back after conferring with his client, with his officials. First post in the second week of January. Next.
Deeply obliged.
Your lordship, my name may be reflected.
Deeply obliged.
Item 20.
Please, your lordship.
Yes,
I have filed an application for amendment, my lord.
Amendment also. Revaluation of answer scripts.
My lord.
Revaluation.
Any provision is there for revaluation?
Re-edition.
Re-edition.
Re-edition, rechecking.
But my paper is misplaced by the authorities, my lord. They are not providing, my lord.
Only that paper is misplaced or rest of the papers also?
That paper.
Only that paper. Then there is one judgment of which court which said rest of the paper should be looked into and based upon that some decision has to be taken.
My lord.
Because other papers will tell you are fake.
My lord.
We see some
PQ method.
PQ formula. Okay. Take notice.
Well, there is dissimilar. Sambalpur University, either notice or to panel of law.
One emergent notice to the rest. It is open to the petitioner to serve copy of the petition on the council, panel council, usually representing the university.
Sambalpur University.
Yes. In addition to taking usual steps. Okay. Next.
Item 21.
Yes.
Lord, the matter relates to appointment under the Rehabilitation Assistance Scheme. My lord, earlier the petitioner has approached this honorable court because his case was rejected on the ground that 1990 rules is not applicable, 2020 rules is applicable. Your lord,
Presentation sufficient.
no, that amendment. Second, your lordship may kindly hear for a minute. When I approached this honorable court, challenging the rejection order dated 10/9/2024, that rejection order was passed on the ground that since 20 rules have already come into force, so your application for appointment under the Rehabilitation Assistance Scheme in accordance with cannot be applicable. Although my father died prior to coming into force of 2020 rules. Then this honorable court quashed that order and directed for reconsideration of my case.
The old rules.
Old rules.
Said old rules are only reconsidered.
No, old rules.
Old rules.
Thereafter, now again that has been rejected by virtue of order at 18/10/2025 by taking a plea that two cases of similar nature that is pending before the Honorable Apex Court. So unless those cases are decided, my case will not be considered.
So your LR has to come for application. Let them take notice and come back.
Short return they will take.
Yes. Issue emergent notice. Mr. 1, 3, learned AG requested to accept notice for 1, 2, and 3. Emergent notice to 4. 4. Post in the second week of January, since matter involves claim for compassionate appointment. And it is a second round litigation.
Yes.
Item 22.
May I please, Lordship?
Yeah.
Lordship, in this case, the petitioner is challenging the action of the opposite party number 2, who has issued an advertisement for recruitment in the same department as the petitioner is working in.
To continue your engagement?
Yes, Lordship.
You were with effect from which date you were disengaged?
No, Lordship, I am still working.
You are still working?
Yes, Lordship.
But read your prayer.
Yes.
To continue engagement of the petitioner as assistant professor.
Lordship,
Get faculty.
Lordship, as the new advertisement is for recruitment in the same department and in the same guest faculty post, Lordship, the petitioner is apprehending that she might
terminated.
Yes, Your Lordship. And as this is in the middle of the session, Lordship, she won't be able to find another job. Your Lordship was pleased to.
This is in respect of appointment of guest faculty. While they are
Again, you are for the appointment of guest
they are
faculty.
continuing, they have advertised, and it is under the my lord, university.
Your Lordship was pleased to.
Dharandhara University.
Notice.
Similar
Lordship,
matters
interim-
also in case of others millets as passed this.
Lordship, interim order was also passed in this.
Third learned counsel, Sri so and so.
Lordship, the
He has
second
made out a case for issuance of the emergent notice to the OPs. First up, he tells the court that his application in the IA number so and so submitted by affidavit needs to be favored. Since a similar relief has been accorded to a similarly circumstanced employee guest lecturer in WPC 31880 of 2025 between Sunil Kumar Behera versus State of Odisha and others. Wide order, interim order dated 12/11/2025. First, he is right in telling this. Next paragraph. In view of the above, the application having been favored, petitioner shall be continued with the same terms and conditions during the pendency of the petition. Okay.
Lordship, the second item is also similar.
Same.
Item 23.
My lord. Matter relating to recovery, my lord. That is the covered by law.
Recovery.
Yes, my lord. I have corrected the copy.
The refixation of the
Which was that judgment?
Yogeshwar Sahu. Yogeshwar Sahu.
Lordships also relying that.
My lord. Same order. Call along with. Also call along with. No, that one, but that also call along. Yes.
Item 24.
For my lord. RACP matters, my lord.
RACP.
Yes. Your lordship's order, my lord.
Change factors.
Yes. Only the prayer will be changed as per the.
A prayer column has to be substituted, na?
Yes, I have already changed.
Both the matters.
Both the matters.
Thank you. Yes.
Item 25.
My lord. My lord, here the petitioner, pursuant to the annexure 1, my lord.
You are one learned counsel who does not need mic at all. Perhaps we may need a silencer. No, I just nailed it for a humorous way.
Sir, pursuant to the annexure 1, the petitioner as an in-service candidate to appear that OTET examination.
OTET. What is
Orissa
that?
Teachers Eligibility Test examination. By the annexure 1, sir. The last date is today. That he has to appear. Because in absence of that certificate which has not been issued, in my favor that has been delayed, I could not appear the test. So, my lord, to direct to appear the test, that is their criteria. If I fail to produce that certificate, they may cancel my result. Also, because I am an in-service candidate. Please see the annexure 1, sir. That is, it is for the information to all the concerned that the applications are invited from the eligible candidate fresh in service for appearing the Odisha Teachers Eligibility Test 2024 as per the following guidelines. The last date is, sir, that is today. That is
today. What type of examination?
That is OTET examination.
When it is?
It is 17/12.
17/12.
17/12.
We'll issue emergent notice and we'll call it on 8/12.
But only to appear.
No, question is, on that date we'll decide that.
Sir.
Issue emergent notice. Or you will permit him to appear.
Yes.
Then subject to result.
Yes. My long friend
issue emergent notice. Mr. Mohanty is requested some notice for 1 to 5. Emergent notice to 6. Next paragraph. Learned counsel for the petitioner draws attention of the court to IA number so and so, supported by an affidavit, telling that his client should be permitted to take up the OTET examination subject to result of the petition. First off, he also fairly submits that the let result of his examination be not announced. First off. Announced until further orders. First off, he highlights the likely prejudice which his client would be put to come up if interim prayer is not accorded. First off, thus a case is made out for granting reprieve. As that first. Petitioner shall be permitted to take OTET examination, ensuing OTET examination first off. However, the result of the examination shall not be announced. First off, petitioner shall not plead any equity on the basis of this reprieve order. Next, both matters.
Item 26.
25. Okay.
Lordship 26, Lordship, there are two items, Lordship. And both are, Lordship, that transfer matters of teachers. And in Lordship, both are also, perhaps it covers the Lordship's judgment.
Show the order.
But Lordship, kindly see something different. Lordship, state I come to page 32, Annex 5. Has to brief, Lordship.
32.
32.
This was in July.
July, Lordship. Here, Lordship, Minister MLA recommends that my name at serial number 9. Something different, Lordship. 9.
You are already relieved. You are relieved now.
I'm still continuing, Lordship.
How? You are also support of some MLAs?
No, Lordship. What they have done, Lordship. Plus, this is a recommendation. Now, Lordship, kindly come to Annex 2, Lordship, for a moment.
Annex 2.
Annex 2. This letter is very interesting, Lordship, kindly see. Lordship, here page 17. Here, Lordship, DO accepts a letter on 1911, Lordship, and this pupillate of this letter, Lordship. On 1911 or 25, DO accepts this letter, recommendation of DO. On 20th, Lordship, he passes order with approval of the DLTC. Lordship, it never possible, Lordship, if at all, Lordship, he accepts a recommendation, proposal of this BO, Lordship, supported to this ML's recommendation, Lordship. Lordship, and on 20th, Lordship, how, Lordship, this DO invited, Lordship, this DLTC, presented by the collector, and on the same day, he passes this order, 2011, Lordship, next page. He transfers me, Lordship.
Issue merchant notice. Mr. Behra is requested to accept.
My lords, page 18, kindly see the requirement for transfer.
Yes.
Page 18, your lord.
But MLA is involved in this.
It doesn't say that.
Why?
It
is there.
Because that is July.
Correct. MLA is pressing that letter.
The reason is assigned. That is what I bring to my lord's notice. Page 18.
Yes.
There is deficit of teachers. That is why.
That is to give effect to MLA's letter. That is all. These things are presumable.
No, my lord's reason is given. Let him file appeal.
Departmental appeal.
Lordship,
and I stay this.
No, Lordship. Lordship.
I will stay this also.
Lordship, because judgment is covered, Lordship.
Today I have said the departmental appeal should be decided in the light of that judgment.
Lordship, grateful, Lordship. That is correct. That
Petitioner's grievance is against the transfer order dated 2011, 2025, copy whereof avails at Annexure 2. First off, learned counsel for the petitioner submits that the order is vitiated in the light of parameters fixed by this court in WP number, today's council matter, number 1, first matter. so and so decided this to, and therefore the impugned order is liable to be voided. Full stop. Next paragraph. Learned AGA, Mr. Behura, submits and this court agrees that petitioner has got an alternate remedy of presenting an appeal at the departmental level under the transfer guidelines dated 14/5/2025, as has been observed by this court in the subject case itself, and therefore court should decline indulgence. First off, there is some force in this submission. Next one. Having heard learned counsel for the parties and having perused the petition papers, this court disposes of the petition with liberty to the petitioner to put the subject order in challenge in the departmental appeal within a period of 1 week. And till that appeal is heard and decided, the impugned transfer order shall be kept in suspended animation, so that petitioner shall continue in the place wherein he has been continuing as of this date. As of this date. First of all, contentions are kept on. Next.
That's the connected matter.
Same.
Same, but let's say be ex-cadre. It can be, let's say, kindly stated come to.
Ex-cadre guidelines, they are also covered in that.
Covered, let's say,
File appeal.
Appeal, let's say.
Same order.
Gratefulness.
Common order. The date of orders are different.
No, same.
Same transfer orders.
Same authority.
Petitioners or transfer orders, that way plural. Okay.
May it please, Your Lords. 27. 27.
I am from the opposite part number 4. I have already filed counter. That has not come along.
You have filed counter now?
Yes, ma'am.
That has not come up here. We'll call the counter office. We'll call it. Ready? Okay. Let's bring that counter. Also.
Your Lords, may I take up next week, 2nd or 3rd?
All right, next week, at the request of. Yes.
Second, ma'am.
Registry to put up the counter. That's even if there are missed non-compliances. Okay.
And not second, ma'am.
Huh?
Second December.
Next week it will come. Okay. Next.
Item 28.
Yes. This is a case of transfer on the recommendation of the MLA. You will also may kindly turn to Annexure 1 at page 14.
You file appeal and same order which we have made them.
Yes. You will also proceed.
The subject matter of this petition is
directly covered by your Lordship Judge.
Similar to the one treated by this court in WP number first matter. So between so and so disposed of this state by a common judgment. Wherein inter alia, the right of appeal is recognized against the transfer order of the kind. First off. Therefore, the AGA, Mr. Behura submits that the petition should be disposed of with liberty to file appeal
within 2 weeks.
Appeal, keeping open all contentions. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to avail remedy of appeal, departmental level, within 1 week. Yes. Until appeal is heard and decided, the impugned order of transfer is kept under suspended animation, provided that petitioner has not yet been relieved. All contentions kept open. Next.
Yes.
Item 29.
Yes, 29. But Lordship may call it next week.
All right.
Next. Well, at the interim order passed by
my lord, I have taken instruction that it is complied with. I will take
complied
it.
with.
Yes, it will be complied. He assures that it will be complied with.
Learned AGA will give you 2 weeks for compliance. Learned AGA assures the court of compliance on or before the next date of hearing.
Yes.
First of all, the submission is taken as undertaking on behalf of his jurisdictional official. First of all, call this matter week after next. Yes, sir. Why they are not complying with? Non-compliance may result into striking of the defense. Okay. In addition to other penalty actions. Yes.
Item 30.
Item 30,
Yes.
the paragraph H, the intervention petition filed by Janganandana Mahapatra, he has filed the intervention petition, but he has not served that copy. I am for the petitioner.
Yes, may I submit my yesterday, other two matter, that sexual harassment matter, petitioner has come up earlier and lost the case. They are shortcutting the things so that it
No, I
all
shortcut. You will serve that copy.
Can't he make
Here no local standing to intervene in my case.
But don't have a Lucas try to request him to make the submission.
My humble contention is that, but yesterday the two of my matters were there. Mine are featured next week. Well, that all the three matter may be tagged up so that it can be taken up. And
meanwhile, you give copy.
Yes. That's I'm giving
Copy, both.
Yes.
I have also.
WPC number 2681 of 2000. All the matters.
Plus, due apology. I am also appealing for another intervener. Plus, on my there also I have sub.
Next.
I have soft copy on my learned friend. In this case, just I want to just remind your lordship. In this case, on the same cause of action, plus earlier the writ petition has dismissed as not pressed.
Let us get appeal. Yes.
His appeal is writ appeal is pending.
No. You plus my
some argument for the next day.
As your lordship is placed. But my learned friend has deceived the court. That is not the way my learned friend is making the submission. Grateful to lordship.
Yes. Yes.
Item 31, I'm trained for the appellant and I am for the opposite partner 5. Opposite party, yes, 5. And for 4, perhaps I am appealing for the government. And government is there. But outset, without going to the merit of the case, but may I suggest, subject to acceptance of my learned brother, although 2 cases was filed by the 2 appellants, 2 applications before the state education tribunal. My case was allowed. I am the opposite partner 5 here in this appeal. But my brother's case was dismissed relating to the post of 3rd post. In the meantime, lecturer in English, 3rd post of lecturer in English. In the meantime, what has happened? From 2015, Santosh Kumar Dalavera, who was holding the post of 2nd post of lecturer in English, service has been terminated on the ground that he was involved in the cheat fund case, and from that date absconded, and no litigation has been till date. After 11 years,
that vacancy is available. That vacancy is available.
Yes, vacancy is available, and I am the 3rd. He has been issued with an appointment letter expressly as the 4th post. He can also get the block grant. Both can be accommodated if possible. Then explore the possibility.
You are client in 2nd vacancy. He is client in 3rd vacancy.
It is the governing body to adjust. And both the posts, since the 2 posts will be admissible, but the principle of law is granting it always being released in favor of post, not in favor of the individual. In view of that, the governing body explored the possibility and everything. And my post has been approved.
Governing body.
And my lord, one thing also, my post has been approved. Pursuant to the judgment of the state. I received 5 months salary, but because of the stay, I am not receiving from 2018 to till date, despite due descent. Although my miscase is there for vacation of interim order, but since this is the possibility, that's why I suggest this to my.
Who appeals for the management? I am for the principal. Milord. Yes, post is. I have held the aid is to the post, granting aid is to the post, not to the incumbent. Therefore, the grant would continue as it is. Only thing is, he will occupy the 2nd vacancy. You will occupy the 3rd vacancy. The whole matter is over.
If the law permits your person,
this can be done.
But if 3rd person is getting, subject to minor accident, 3rd person is getting block grant or approved against 3rd post.
Correct.
That means 3rd post justified.
Now,
if 3rd person will adjust to 2nd, and I will be adjusted in 3rd. So
because 3rd is also
that is to grant. If I will direct, so in that way, 2nd and 3rd can be adjusted, and both will get granted block grant. Then matter can be disposed.
You write a common memo like that. But nobody will be put to prejudice.
But what about that 2nd post?
My seal on that.
My lord, What about when the second person who was continuing the second when he will come back?
That risk he will take.
Then I will come back to the again similarity.
We do not know. We do not know. We do not know, but that may not happen because he may come.
Clarify that.
His whereabouts are not heard. His whereabouts are not heard.
Till date, I think perhaps this.
No, when he will come back and file a case,
to
my severity is so.
Reopen the case here.
Lordship may clarify that.
Yes, this case will be reopened. Yes,
whatever will happen, happen. At least till then, all you will get.
Yes,
some apple got.
This is on my
You prepare a memo, so that I will reproduce that memo, and I will direct the formalities to be complied with to the government also. Because government could not say, you have entered into this arrangement and it is not binding us. Make that memo.
After lunch.
Well, not after lunch. 5 minutes.
Yes, we'll three.
But I will write it because my father suffers suddenly at an accident. I will leave the court.
No issue. But if you put signature, everything will be over within 5 minutes.
I may not be available.
But my lord, governing body has nothing to say. Your lordship will only comply.
Take that direction.
Governing body.
You have to give one memo.
Governing body has to.
May I let it come on tomorrow?
Tomorrow you will attend this one. Yeah.
Item 32.
Substitutional petition, my lord. Petitioner died on 9/3/21. I have filed a substitutional petition to be substituted the legal heir, which has been mentioned in the substitutional schedule of that substitutional petition.
LR application.
My LR, correct.
Delay is there.
The delay is there, my lord, to the list. Near about 5 up to 6 months.
6 months. Who pays for the other side?
The government under the governing body. I am there.
Will allow that LR application. Is it appellant or petitioner? What do you call it?
Appellant.
The appellant having died on
9/3/21.
9/3/2021. Two applications have been moved. One for seeking condonation of delay in filing the LR application, and the other for setting aside the abatement and LR application. First off, both they are supported by the affidavits. First off, cause of action survives.
First appeal was dismissed earlier. First appeal was dismissed earlier. Dismissed
Was it dismissed earlier?
It was dismissed, restored. That is what
restored.
It was restored. My record doesn't show that it was restored. No, just
whether it was restored. Otherwise, it would not have come that way, na?
Yes.
See, was it dismissed?
It was dismissed on 23/4/2023. Non-appears dismissed.
But 9/8/24, considering the grounds of a delay in filing restoration, so inside.
9/8/24, my lord, my
9/8/24, it is what kind of order?
Allowed by order dated 9/8/24.
Ordinarily, applications of the kind are leniently viewed by the court. First, explanation offered for filing the condonation application. Application for condonation of delay being plausible, the same is favored and delay is condoned. Now, the abatement, if any, is also set aside. Next one. The application in the LR application in IA number so and so having been favored, the LRs are permitted to come on record in the stead of deceased. First off, petitioner to amend the cause title and file the amended cause title as well. File amended typographed amended cause title as well. Okay. Next.
Item 33.
Yes, sir.
page 33. The impugned order is at page 33.
Your file is very attractive. The cover of the file is very attractive. Yes.
माइक टा यूज करो यूज द माइक
Just mic. Lordships, relevant is at page 34.
34.
34. Lordships, without going into the factual aspect of the case, the learned tribunal dismissed it by saying that it is covered by Loknath Behra reported so and so. Page 35 is the relevant.
Not covered.
It is not covered.
What do you say, Mr. G?
My lord, what he speaks, my lord, page 34, the order, impugned order. He speaks that it is not covered. But the applicant, what it appears, my lord, it is covered because the applicant who is working as a lecturer in logic against the first post in Rukmini Devi Chilika Mahavidyalaya at Chilika Nuapada in the district of Puri. In this application, so and so, from the record, it appears that, second paragraph, the applicant was appointed as lecturer in logic against first post on 4/9/1990 and joined on the same day, and completed the qualifying period of 5 years on 3/9/95. During the currency granted order 94, the post of the applicant was not approved. The granted order 94 was repealed on 5/2/2004. On implementation of granted order 2004, during currency
of 94
order, since the applicant was not approved with release of granted, now it cannot be made in terms of para 4 of the granted order 2004 vis-a-vis the order of the Honorable Court in case of State of Odisha versus Loknath Behra and another reported in 2018-2 ILR Cutter 535 and the judgment of the Honorable Apex Court in case of Loknath Behra versus State of Odisha in civil appeal number so and so.
It is affirmed by the
Apex Court.
But whether it is applicable or not is the issue.
The issue involved in Loknath Behra, which envisages 3 guidelines, but that guidelines are just shown to my lord.
Can you share a copy of the judgment with me?
Let's see. I've got I've got one copy. It will be sufficient. No, let's see. It will be sufficient only on the heading, part 1, 2, and 3. I'm covered.
Just you read and I'll just listen. Let us see. Mr. G, you also lend your ears.
The 3 conditions which are to be filled up for getting the benefit of granted. First, the post is to be admissible as per the workload and yardstick prevalent prior to 1/6/1994.
That granted order
94. Just answering to this, my client joined on 90. That is
no dispute.
That is no dispute.
That is mentioned in the second paragraph of 4/9/1990.
4/9/90.
Yes.
Then second is has been filled up prior to the date of 1/6/94.
Covered. 1/6/94, yes.
Covered.
No, sorry. Because
kindly bear with me.
Next time, you bring a chabka. to keep all government advocates mum in the court hall. They are saying their version. Anyway, we should take the intervention.
The thinking process goes down. That's what I am telling.
No.
Please.
Sarnati,
let my learned friend finish, no problem at all. Because my lord,
everybody they're being entertained by both of.
Kindly finish. Let him finish. He is the senior counsel. Let him finish. I am told.
No problem. You do it, Lal. You do it. Both myself and G will keep quiet.
Lordship, that banana was so nice. I succeeded in 4 cases.
Which banana?
The one that was given. You did not get that.
Yes, I got.
Have you got that?
That was from the garden. That
He said, being sugar patient, I took 1 piece. That was very nice.
Taken medicine also?
I taken.
Then not. Your family should not lodge a complaint against the judge, saying that my husband's health is marred by the act of the
Sugar gave me boost, Lordship. That banana. Then Lordship, class 3. The qualifying period of 5 years for the urban areas, class 3.
You are appointed on 4/9/1990.
Class 6.
4/9/90 is appointment.
Lecture in logic against the first post.
Tarkashastra. Yes.
Let's see. 1694 is the cut-off date. As for the grantinate principle, as envisages in Loknath.
So your appointment is within the cut-off date.
Within the cut-off date.
Yes.
Clause 1, I am through. Clause 2, I am through. Clause 3, each qualifying period 5 years for the urban areas or 3 years for the rural areas, as the case may be. Meaning thereby the provision may under paragraph 9(2)(b)(1)(a)(b), that is grantinate order. I'll take to that provision. Each with respect to the post and paragraph 9(2)(b) clause 1(c) stipulates with respect to the qualifying period of 5 years or more or 3 years or more. Now for getting grantinate, Lordships, I am bringing. For getting grantinate, the incumbent should continue without break for a period of 3 years, 5 years, or 7 years.
With effect from?
Workload and the date of joining. With effect from the workload. Because in some cases, let's say since my lord is hearing it in length, in some cases we find by saying one has continued for 1 year, thereafter he gave the resignation and another man came.
That period will count.
That period will count.
The doctrine of tagging.
So, in that eventuality, I am not focusing that point. Here, straight away, I have joined on the first post. Therefore, there is no quarrel against that. So, what I am submitting, I have completed qualifying period of 5 years.
Now, where is this order does not refer to all that at all?
That's precisely, that's why I am before my lord.
Okay.
That's why I am before my lord.
So, remand will do it justice, is your worship?
No, Lordship.
I only have to do the order.
Lordship, why I am saying, in major of these bunch of cases, it is pending before the Honorable Supreme Court. Major, where I am appearing before the Honorable Supreme Court. And last occasion, your Lordship says also, in regards to the review petition
it's not maintainable. That also I filed a SLP. I did argue before the Honorable Supreme Court that notice was issued. Your Lordship's order is tagged with all this. So I am saying, Lordship, let them file a counter so that everything will be heard.
You could have made it as a first sentence itself. This is what you could have made. As the first sentence, I would have said that order in one line.
Lordship, because they may tomorrow they may say, Lordship, they have not given chance. Yes, why I am saying in my experience, Lordship.
Now you have seen him.
My Lord.
He will not leave the things here. He will take you to the Delhi, to you and me also.
I'm afraid of.
It is better for my protection. You file your counter.
First, let him condone the delay here.
Delay, Lordship, has been condoned, my Lord. Because after M.R. Gupta case 1994, since my
apex petition,
M.R. Gupta case, since
17/10/2019,
not when India is a continuing cause of action. Survives every day.
It is not that. It is not that. It is
decided as per law.
Order was passed in the year 2019. And the appeal was preferred on the year 2023.
Anyway, that during that particular period, if you want to say something, we will say that he will not be entitled to get that benefit.
But
that delay we shall come. You will be subject to, you are denying the benefit for the delayed period. So that no prejudice will be caused to you. For rest of the period, he will be entitled to the benefit.
No, he's not entitled.
If at all, if he succeeds.
Succeeds.
If he succeeds.
It is better, my Lord, if you will go and approach the tribunal again, so that the tribunal can pass and
the tribunal
that is good. Please,
it is his submission.
Please take your own It will be better, my Lord. He can adjudicate the disputes there. It is his entitlement. He will decide there.
The like of Loknath Behra.
Whatever, yes. So
that he has said it is covered by Loknath Behra.
He said it is not covered by.
Whether the new judge has come or same judge continues.
No. New judge has come. Yes.
We'll tell 1 second. Without hearing me, you have to give me an opportunity of hearing to the judge also. Principles of natural justice apply to judges also. Is it not? Now, what I suggest is, I will keep open all contention.
Yes.
New judge has come there to the tribunal. I will direct him to decide this appeal within 2 months and report compliance to the Registrar General of this court. Are you not happy? I will give you 2 more bananas. We'll make a consensual order. We have to condone the delay now.
Yes.
But you run one risk. Once delay is condoned here, that is whatever benefit you would have had by virtue of condonation, you will not have before the tribunal.
No.
Yes. That will give advantage to you. Yes. An application has been moved in IA number 459 of 2023 seeking condonation of arguably long delay of about how many years?
About 2023, 3 years.
About more than 3 years. 3 years. First,
4 years.
An explanation has been offered to the delay proved. First off, appeal of the kind cannot be rejected only on the ground that delay is too long, even when explanation is found to be plausible. First, condonation of delay would not add any merits to the case of the appellant, to the detriment of the others. First, in the above circumstances, delay having been condoned, application having been allowed, delay is condoned. First, you give one good book to the library.
I have been giving every month.
Now one more.
Let's see, kindly, I am sitting in the library itself. So I have been giving every month a book.
Then it may not be necessary. This is order. The other another.
If you not
having argued the matter vociferously for some time, agree with the suggestion of this court that prima facie the reasoning of the impugned order does not reflect due application of mine to the ratio in Loknath Behra versus Science reported. And therefore, matter requires reconsideration at the hands of the statutory tribunal under section 24B of 1969 Act. Next part. In the above circumstances, appeal having been favored and impugned order having been set at naught, the matter is remanded to the portals of tribunal, which shall give an opportunity of hearing to all the stakeholders and finally decide the matter afresh within an outer limit of 2 months. First, the compliance report shall be filed by the tribunal with the Registrar General of this school. First, all contingents are kept on.
My lord.
Yes.
If there is, if there is any time is taken, my lord, by the petitioner, then this time stipulated shall be.
The adjournment taken by the appellant shall be discounted while computing the timeline prescribed by this court.
Same principle also apply to the state.
That will be disastrous to you. That will be disastrous to you. Lordship, you lost your advocacy.
Lordship, same principle also apply to the.
That will be disastrous to you.
Lordship,
same. 33, 34. Then we'll give them 3 months because 3 matters are there.
3 months. 3 months. Lordship, 3 months will be reasonable.
I'll come back within a couple of seconds.
Item 36.
Item 36 and 37. Both are state appeals. Can I pray, my lord? Let's take this matter on some other day.
37, I am not getting my salary.
Let us see all these years, 3 years, 2 years are over now. We'll have it in the second week of January 2020.
My lord,
yes.
May I pray the first week of January?
First week of January.
Both are first. Both are first.
Item 38.
Mr. G. Yes.
Item 38.
Masur. 38. This is for admission, is it? No, for after notice it is. 38.
Millard, I am in 38, Millard. May I presume my learned associate was there. Millard, this matter has come for your lordship consideration for the first time, Millard. Millard, here in this case, it is a statutory appeal preferred under section 24C of the Odisha Education Act, challenging the award judgment on learned tribunal, Millard. Here the IA in the IA, the registry has pointed out 6 days delay, Millard. 6 days.
Don't delay, Mr.
Yes,
but in fact, Millard, there is no delay. I can explain it before lordship.
Why will condone delay 6 days?
6 days, Millard.
Other exams.
Millard, there is in fact no delay at all. At all. Why not, Millard? I am explaining there is a wrong from the calculation from the side of the stamp reporter. That should be rectified by your lordship's interference.
Yeah.
Because it's a wrong calculation, Millard. Millard, as per section 20C, Millard, the appeal should have been preferred within 60 days.
Correct.
Date of judgment was 26th August. Let's make I remember. 26 August 2024. 26 August 2025, sorry, Millard.
Yes.
Millard. It should have been filed within 16 days, means on or before 24th October 2025.
No.
Your lordship.
It is not month. It is days.
Yeah, days. That is 24 in my
August
calculation.
will have 1 extra day.
Millard. Then your lordship.
October will have 1 extra day.
October. Millard.
August will have 1 extra day.
Millard. Then your lordship, I have preferred this appeal on 22nd. 22nd.
22nd.
Okay, 22nd October. अरे भाई मो calculation थीटा तो मैं नोट करूँ. That is, sorry Miller. I am prepared on 22nd October 2025. That chart is with me. Registry chart is with me, Miller. And
Then there is no delay.
There is no delay at all, Miller.
No delay.
From that, Miller.
By abundant partial application in the higher number, so it is so supported by affidavit is filed seeking condonation of a short delay of 6 days. First half. However, learned counsel for the appellant is right in telling the court that the registry has miscalculated the number of days and therefore have projected 6 days delay when there is no delay at all. First, I agree. Therefore, application is disposed of as being unnecessary.
Obliged.
Not.
Miller here.
He wants time, na?
Obliged.
The third week of January 2026. Not at the request of learned AG. Yes.
Maybe possible in December, Miller.
December not possible. December only roses are possible. Roses, famous book, roses in December.
But
Chagla.
But roses is at the end, but we are in anecdotes, Miller. When the early ride, but
many matters we have posted. Otherwise, I have posted also.
Any early date will possible before last year.
Second week of. Not.
Obliged.
Item 39.
My lord, item 39 is the covered one. So, on the last occasion, my
instruction, paying for time.
My lord, I object.
He's saying
because this is a covered case. For time, my lord, because what government advocate will instruct, department will do accordingly. They cannot do anything on the advice of the department. It is a covered case. So, similar matter your lordship has disposed of. So, it may be disposed of on that light. So, your lordship on the last occasion said you give a judgment copy. I have given it. So, next week.
We find the government advocate also. They have sought for 4 weeks time. You have sought for 3 weeks. We will give you. At the request of learned AGA, Mr. Lenka. Yes.
Item 14.
Please, your lordship. This is a case, my lord, which was heard extensively, my lord. And we are stuck up a point, my lord, where your lordship was to...
You have to freshen my memory.
I will do that, my lord, right. My lord, in fact, BDA, Bhubaneswar Development Authority, my lord, in the name and style of Kalinga plotted development scheme, floated brochures, my lord, inviting applications for open bidding, e-bidding, my lord, for allotment of residential plots, developed plots. My lord, may kindly take note of plot number K-4 by 1306. A-4 by 1306. Along with the area, my lord, that is relevant. It measured, my lord, 1200.
Just can you make a statement of the case within 3-4 sentences?
I can.
So that in the light of that,
I can, my lord. The conflict is between two plots. Which one is the larger in size? The other one is smaller in size. Auctions were held in 2 spells. In first spell, the petitioner emerged as the second highest bidder in respect of a plot which was of a smaller size, 1250 square feet. According to the brochure condition, there was no prohibition, there was no restriction, my lord, to apply for any other plots in case BDA floats any other further schemes.
No restriction.
There was no explicit restriction, directly or indirectly.
Any number of options you can plot.
Yes, but you have a right to have avail only one plot. But so far, applying for various plots, my lord, there was no restriction.
But when
eventually, my lord, sorry.
So in multiple bids you can participate. But even when you are successful in all the bids, you are entitled to choose only one.
Only one. You cannot have more than one plot. So the first auction, which was irrespective of the date, my lord, it was held. I was the second highest bidder of a plot. smaller size plot. The larger size plot, when I auctioned, my lord, I emerged as the lowest bidder. It means I became the highest auction purchaser. I quoted the highest price. H1.
Not lowest bidder, highest bidder.
I correct myself, my lord. I was the highest bidder
in the first auction that was held earlier, in respect of a small site, you happen to be the second highest.
Correct.
In the second auction, in respect of a larger site, you happen to be the first bidder.
Highest bidder.
First highest bidder. Whether what happened to the first highest bidder in the first auction?
She or he did not like to take the plot. So the decision of BDO was, since the highest bidder opted out,
you become the highest bidder.
Therefore, you are bound to take the smaller plot, even though you are the second highest bidder, and you are not allowed for the second option.
May not be correct.
And your lordship heard it. And we are stuck up at a point, my lord, who quoted how much price? Because the counter affidavit filed by the BDA was bereft of the exact amount that the chosen one, my lord, had quoted. Because that.
Now, you for a moment. You are highest bidder in both.
And
in both. Still, you are entitled to say no to the first auction, and you can go for the second bigger plot is your worship.
Had it been my lord, also I would have. But here the case is, I was admittedly the second highest bidder, and I went for.
What is the time gap between these two auctions?
The result of intimation to me was on 23, exact dates I am mentioning.
Auction happened when first plot number K4/1306.
Measuring area 1250 square feet.
Okay.
Auction was held on 10/3/21. And plot number, the other plot, my lord. Plot number K-5/477. For an area, my lord, 2037 square feet. 5/477. 477.
It measures
2037 square feet. And the for
2037.
37, correct.
SFT.
Square feet.
Auction was
held for the second one on 25/3/21. 25/3/21.
What is the time given for rejection of the bid of the highest bidder?
I was for the first time intimated, my lord, about such a stipulation.
Under the rules, within how many days the highest bidder should remit the remaining amount?
That is reflected at page 16 of my repetition, annexure 4. No, highest bidder.
Highest bidder will remit 25% on the 25/30, whichever is there. For remaining amount, remainder of the amount, he will be given tax. Is it correct?
Correct.
The law of tender options.
Correct. It is almost everyone, ma'am. It is correct. He or she opted out. He did.
No, I'm asking. How much?
How in this time was given?
My lord,
I'm
not arguing.
No, I am answering, my lord.
My lord, if you will permit, I will place 3-4 dates for my lord's appreciation about fact.
I'll take those dates also. I am very interested in eating Arabian dates also. That's another thing. I am asking you, under your norms of auction norms, auction takes place today. He credits 25% of the amount, whatever amount is.
EMD, my lord. The fixed EMD 5%. After being selected, they are to require to pay 10% of the total bid amount they quoted.
What period?
within the period
10 days.
10, no?
That I wanted to.
Please allow me to complete wherever
Exactly minus 1.
I'm answering and you intervene. Wherever I fail, please supplement.
I requested it.
Sir.
In both the cases, 10 days only.
Condition remain, brochure condition is identical.
Identical. Where is that condition, sir?
Brochure is annexed to the affidavit filed by the BDA, my lord.
Go to BDA.
I will only factually apprise your lordship what is my grievance.
No, going by your version, coupled with my fading memory, your KC, you should have been given, going extreme. Even if you are the highest bidder, I will give up the first auction, go for the larger plot.
That can also be done.
That is one argument. Lesser point is, anyway, 10 days are given to the first bidder to say no, to withdraw from that, this one subject to forfeiture, etc., etc.
Exactly.
If that first bidder opts out within the 10 days, on which date she opted out?
Intimation was given to me on 23/3/21.
No, that is after the opting out.
That is
Perhaps you may not be knowing the date. That's not that. Which date? The lady.
In fact, the case is not that manner.
No, anyway,
here in this, there is no contingency of any date
at all.
Because on the date of the auction itself, it is
auction.
Auction held, my lord,
10-3.
10-3. The principle is like this, manners. An applicant, suppose I want to apply for, I can apply for a hard, but suppose it is a e-auction process, in respect of 3 plots. I can choose 3 plots, I can apply for. But fact remains, suppose my lord X applied for a plot, I also applied for the same plot, he quoted a higher value, and then he will be the person, suppose again he is also quoting in respect to another plot, so the amount he quoted highest will be eligible for that plot. No option is necessary for that. Automatically it will go. Then manner the second person, in respect of the second the plot which he quoted highest, the X quoted highest, the second option also the second bidder will be the selected bidder.
That amounts to compelling him to take a smaller size.
And that is the condition specified in the, but the dispute there manners, the smaller size and bigger size. But fact remains, this is the condition specified.
Both the plots are now available or given to anybody?
No, available.
I'm appealing for the appeal 426, my lord. Plot has already been allotted in my favor.
No, that is in the
entire 80 lakhs or I have deposited.
Yes,
Exactly. Now the quantum was a point where we got stuck, my lord.
No.
I would have started from the quantum.
Allotment has been made in my favor.
Well, sir, may I clarify the things, my lord, because it's very difficult because these things are like this, my lord. It becomes very difficult to bring it enough.
You have made him to sit him.
But not that I am not supporting this side or that side. Thing is that means what has happened, in fact, let us understand. Thereafter, minus what is the law? Minors will decide. Fact remains what the auction process is like this, minors. 20 number of, suppose 18 or 20 number of plots are going to be auctioned. So we floated a brochure and brochure conditions are there. The brochure condition specified, any applicant can choose 3 of the plots and can bid that they file the bid.
Not choosing 3 plots. He apply in 3 different options.
3 different plots, 3 different bids.
Yeah.
Putting 3 different values. Maybe it is his choice.
No, last sentence confuses me.
Yes.
Other 2 sentences I've understood.
Manners.
But last sentence does not fit into my idea of...
I'm clarifying. I'm trying to clarify once. Then manners auction will commence, manners. In auction, but the auction process will go on, tendering process will go on. So then in the process, he also participated in so far e-auction in plot number A, participated in e-auction in B, and e-auction in C. He quoted highest in respect of A.
Then he quoted, suppose he quoted in respect of A, then he quoted highest also in respect of the B and in respect of the C. Then which plot he quoted highest, he is bound to take it.
All the three he has quoted.
No,
highest.
all the three he quoted highest. Among the three, suppose he quoted 86 lakhs in respect of A plot, 84 lakhs in respect of B plot.
The highest money.
Highest money.
Let us see that button so that how can that be the percentage?
Balance caliber glass 2 is.
Does it not have any relationship with the extent of the aerial extent of the plot?
That is an area specified in the brochure. Looking at the area, size and everything, they must submit the bid.
No, there can be.
Yes.
Even for a larger extent of site,
Yes.
it is possible that there may be a lesser amount of quote.
That exactly, Miles, I will come to that. Miles, comparing the both Miles, I will come to that. Miles, kind of glass
Which
Miles, kind of glass to that. Miles, to finally come to Miles, my counter, the internal page 10.
VDA counter.
The counter. These are all what type of things. Sometimes the language doesn't come to the tongue, my lord. That is it.
No.
That's got it, man. Page 10.
Page 10.
Yes.
That is our running page 33. 194Q.
Yes.
Scheme details. Correct.
Yes, it's running page 30.
Give the file or copy. Any development is done on the plot? Have you done any development?
No, possession has not been. Possession has not been.
Possession is not given.
Plots are like the pendants of the intact one.
Because of the pendants of the appraisal, possession has not been given.
But here it is arbitrary position.
I have decoded it.
Arbitrary position. We have issued allotment letter to him, and he deposited for 80 lakh since the date of the allotment within the time period specified in the allotment.
No possibility of amicable settlement also.
That is specifically directed all of us. We tried, we failed. Because this is a case of clear collusion out of the sweet that is what I am going to prove when my turn comes.
It is all right. Where is the contingency of collision, man? Where is going on? There might be some of the conditions may not be suitable to you or suitable to others. The brochure conditions. But there is no contingency of any collusion. Got it, that is page 10.
Yeah.
Scheme details, the list of assets under action. That's the dispute so far the present plot is concerned. K 1306. 1306. Second block.
This matter was heard by any other judge?
No, my lord.
No.
Extensively by this honorable court only.
Once it was argued balance before.
Once it was about to be completed, where I was asked to, my lord, 45 or something.
What I suggest is, let him complete his argument.
Right.
Then it will be...
Right.
Yes. Plot numbers you have given two.
I have given correct.
Two auction dates you have given.
I have given both the auctions.
Yes.
And for the first time, my lord, the petitioner was informed about the situation, my lord, that make him troubled. That is Annex 4, page 16 of my red petition. I am reading, my lord. This intimation was made to deposit the remaining EMD for considering of provisional
first plot.
First plot. Allotment of plot bearing K4/1306. Madam, sir, Bhubaneswar authority is glad to inform you that in the e-auction held on 10/3/21 for plot number so under Kalinganagar plotted scheme, your final bid amount, so and so, 70 lakhs, only has been selected as H1 bid. I am disturbed with that, my lord, because admittedly I was the second highest bidder.
So, first sentence says that they are glad. You are not unhappy with that. Or you are unhappy with that. What sentence says?
Glad.
They are very glad.
That made me very dissatisfied, my lord. They were very glad because they were engineering everything to favor this. So, As per the condition of the brochure, 7.2, my lord, by mark it, 7.2, you are requested to remit the balance EFD amount of so-and-so, already deposited for so-and-so amount, the amount be remitted to so-and-so. So that is pertaining to EMD, my lord, that paragraph. You are also requested to submit the original hard copy of so-and-so 10 days for taking further action, not relevant. It may please be noted that no extension of time is allowed for remittance of balance EMD. From this letter only, I could know that though I was the second highest bidder, my lord, I have been declared, and they were thrilled to declare that I am highest bidder in respect of a smaller.
This is dated?
This is dated 23/3/21. Correct. 23/3/21.
Annexure 4.
Annexure 4. The letter which I had not received. I had no knowledge.
This letter you had not received?
I had no knowledge. I received letter on, and I responded to that.
But you have produced that?
Yes, Annexure 5. I have not concealed anything, ma'am. All documents I have brought to your lordship's kind consideration, ma'am. Then now the immediate next Annexure 5, page 18. I wrote to the secretary that allotment of BDA plot number K by 5477, 26/3/21. My lord, may kindly take note of. That is a day after I emerged as the highest bidder in respect of the larger plot, for which auction was held on 25/3/21, a day before. There I write, my lord, with reference to the above cited subject, I, Tarini Misra, a resident of so-and-so, I had applied for purchase of BDA plot number K4 by 1306, 1250 square feet under Kalinganagar so-and-so. Though e-auction process participated in online auction held in which my bidding amount of rupees 72,72,000 was unsuccessful in the bidding process.
In the first bid?
This is pertaining to the smaller first auction. I had also applied for purchase of plot number so-and-so to the second one where the larger plot under Kalinganagar plotted development scheme as per the second advertisement in the same month, white so-and-so dated, and participated in online auction and became successful H1 bidder by bidding amount 86,63,000. My lord, may kindly take note of the figure, because just now my learned senior counsel stated
the first bid amount was how much?
72 lakhs.
First bid?
First bid for the smaller
auction.
For the smaller
72 lakh.
Yes.
72 lakhs, 72,000.
72 lakhs, 72,000. And my lord, how much I quoted for the larger one? 86 lakhs, 63,000. Even taking a pause right here, my lord, the clarification just while before my learned seniors gave before your lordship, that even if someone is highest bidder in respect of multiple number of plots, the highest amount he or she quotes for any plot will automatically go to his or her favor.
He should get the
highest. So kindly take note of the figure that, my lord,
what is their amount?
I'll come to that, my lord. Very poor compared to me. I'll come to that.
80 lakhs.
80 lakhs lying with them. I'll give the exact details of everybody's account number. Wherever I am at wrong, my lord, they are most welcome to supplement me.
Yes.
Now, 86 lakhs, 63,000, my lord, in the above bidding.
When you received this letter?
Yes. The previous letter.
Yes.
The previous letter, my lord, my specific stand was after I participated in e-auction on 25th.
In the second auction?
Second auction. On 25th. The time gap, my lord, that is crucial also, sorry. My lord, 23/3/21, they write a letter to me under Annexure 4. 25/3/21 is the date where auction was held. From the beginning, my humble submission is, my lord, there is no restriction or any prohibition.
That I will come to. But you come to paragraph 2 of Annexure A5.
Annexure 5. 5, yes. My lord, yes, correct. I had also
Last 3.5 lines.
last 3.5. Yes.
I received.
My lord,
I received
your letter dated so and so, dated 23/3 21. Amount of ethics within 10 days for consideration of provisional. I do not deny. I write it on 26/3/21.
No, where have you received that? You belatedly received this letter.
My lord, it was received, my lord. I need to.
Where have you stated that? In your letter, you will have quoted it in this letter itself.
In this letter, my lord, that is probably not reflected. No, my lord.
That means you have received it in time.
23. Let us. I will come to that also.
No, I want
just now also
clear on the facts.
No,
first.
just now also to answer my lord's query. Let us assume that I received in the late night of 23 on the same day, which is not practically possible. But let me assume.
Sent by how? How it was sent?
It was sent by post, but they say that they have my mail. They sent it by mail. Let us assume that
mail.
They say last occasion, my lord, my lord.
That can be verified, na? Whether it was there in your mail or not, you can tell that.
That was the same point your lordship pointed out.
No, he admitted also that he has received 1 day before.
1 day before.
Once kindly be close to page 18.
1 day before of writing this letter.
That is exactly, but kindly be close to that. What he is
25th I received that, but that is my case. But to explain to your lordship, my lord.
Kindly look at whatever you have stated. My lord wanted a specific query that when you have received that letter.
From whom? From me or from you?
From me. From me means from BDA. But just 1 day before, paragraph 2, paragraph number 2.
Paragraph number 2.
I had also applied, I start from that.
Correct.
Then, but the line number, 1, 2, 3, 4, 5, 6, line number 6.
But I just 1 day before this
election dated
petition
was held on for 25/3.
Received your letter dated so
23.
That is, he received it on
24th.
No, 26. You sent that letter.
20.
Here, Annexure 5 is dated 26/3.
That is the letter. That is their letter. Our letter is at 23/3/2000.
Correct.
Yes.
In this letter. He says, I received your letter 1 day before.
1 day before
that should be 25/3.
No, 1 day before this election held. Election dated 25/3/2000.
My lord, let us read the
1 day before this election dated 25/3/2000. That is.
Let us read the sentence very clearly, my lord. I received your letter number so and so, dated so and so.
No. Earlier part you have left.
No, I am reading conjointly, my lord.
But just 1 day from there.
In the bidding process, about just 1 day before this e-auction dated 25/3/2021, I received your offer letter so and so dated 23 to deposit. Means let us assume it was received properly and acknowledged on 24/3/21. Can I proceed further, my lord?
24/3. Yes.
My lord, yes.
Others need not wait. They can eat your lunch and come back. Yes. This matter will go on. It appears to be a marathon matter. Yes.
My lord. Thereafter, my lord, 25/3 e-auction was held. I emerged at the highest bidder. And I wrote this letter on 26/3 because I had received the earlier intimation. The earlier intimation was a jolt to me because no such stipulation was ever there. Out of their sweet will, the very foundation of my case is, my lord, what is the restriction that I cannot apply for further? Rather, their case is, admitted case is, one is free to apply for n number of plots. And he or she can also secure a plot wherever he or she quotes the highest value. Now my value part I have sought
Yes.
for your lordship's kind consideration to just to keep in memory. Now in the counter affidavit part, in the counter affidavit filed by the BDA, paragraph 4, I'm straight away taking your lordship to paragraph 4, page 3 of their counter affidavit. That in reply to the averments made in paragraph 6 to 8 of the writ petition, it is humbly stated that in response to the first auction, one Srimati Subhasini Swai quoted highest bid in respect of K 4/1306, the first plot in dispute, my lord. And the petitioner quoted second highest bid of rupees 72,000 and stood the second highest bid. This is the clear admission. Now, my lord, the first highest bidder became also first highest bidder in respect of plot number K 4/426.
There's another plot.
That same Suhasini became also highest bidder in respect of another plot K, that is K hyphen 4/426. And what is the result? As per the brochure condition, any bidder become highest in respect of two or more assets. Quoting highest in respect of particular asset shall be entitled to allotment of the said plot, and rest plot shall be allotted to the second highest bidder. Now, probably that Suhasini chose the second plot where she also was the highest. Now, he can clarify what was the bidding value in respect of two, because we do not.
Whether it is more or less. If it is more, then arguably he will be justified.
Justified. I have no knowledge about, because that is for me, that is so.
What is the amount of Suhasini's second bid?
Suhasini, I got that information. 1 minute, I'll be with me. I got that information. So for K1306, 72 lakhs 92,000.
No, I am talking about the K426, for which
another plot is given to her. She also had participated in the second.
That he has quoted 79. That so for the second plot, that is K. What the plot number K4426.
Correct.
That is 79 lakhs 18,000.
Here, how much she had quoted? In the first bid?
72.
So it was more. So admittedly.
Arguably, he is correct. And I also rely strongly on his submission. Later on, I will justify. No.
If your logic will be, what applies to Suhasini should apply to you also.
Why not? They are
is the argument. Because you are the highest bidder in the second auction. Therefore, if she is favored, obviously you also have to be favored.
How can I be treated differently, my lord? I will borrow everything from their valid reasoning mind. Now, they say more assets quoting a highest bidder. The process shall continue till the assets gets exhausted. Srimati Suhasini preferred plot number K426, and accordingly the petitioner was selected as highest bidder. This logic of compelling me
to go for a smaller plot,
treating me forcefully as highest bidder and restricting my right, my lord, to opt for the second property for which admittedly I am the highest bidder, and the quantity that I have bidded
more than
is
allotee
is distinctly more than the favored one, my lord. Actually made me perturbed, for which I approach your lords. Now the question is, my lord, probably the principle of best possible purchase theory they are adopted for the first auction because the highest bidding amount was sustained. Same principle also be applied, my lord, when state is applying for this. State must secure the highest bid price because this is the welfare of the state. State manages its own affairs. No one should be a victim of such decisions, my lord. Now, rationality, your lordship also pointed out on last occasion while concluding the argument, how much amount did he quote? We were dark because nothing was written on the counter affidavit. My learned friend, my lord, however, after your lordship's direction, gave me the information which is given later on field, my lord, in he came as an intervener, my lord.
Anyway, intervener is OP3 or what?
No, now he is OP 456.
My father was the initial alert. After death, he took the illegal action, he have been included as the opposite party of court.
Now page 7.
Windows here for his job was the
4-2.
Allow me.
4-6.
Yes. Actually, my lord.
Who was 3?
Same.
Father was 3.
My lord, that is my interest.
OP3 was who?
Allow me to.
Secretary Monson.
Yes.
So you are 4, 5, 6.
4, 5, 6.
3 children.
3 children. One wife, 2 daughters.
1 widow and 2 daughters.
Yes.
Now, my lord, the informal,
any amendment is not done. Application
because at the intervention, I have filed intervention petition. That has been allowed.
You remitted money after the filing of the petition?
No, before that.
Before filing of the petition?
Yes, ma'am.
But that money is smaller amount.
The BDA authority.
But it's a smaller amount than his bid.
If I am wrong, he may rectify. Yes.
Your bid amount is 82 lakh.
80 lakhs 3,000.
80 lakh 3,000. You are going to allow that impleading application and add them as parties.
My lord, your lordship formally asked me whether I oppose to the impletion, my lord, because for the adjudication of the case, his impletion, I thought better to.
Intentionally, they have not included as the individual party.
Why was now this is on him to justify.
Since the beneficiary, it has not been added.
The application is allowed already.
Yes, ma'am.
It is, but you have to amend the cost title.
The reason why, my lord, I took that immediately because I wanted early disposal of the case. Now,
but that they are not. You have not amended the cost title. You have to amend the cost title also.
My lord, I had amended, but the copy I had given.
No, you have to amend the pleadings and file the amended pleadings.
No,
that's the requirement of CPC.
My lord, amendment was. Just a minute, my lord.
Anyway, you can do it otherwise.
I will do that.
No issue.
4, 5, 6. I admit that they are opposite part number 4, 5, 6, my lord. I am concerned with conduct of 1, 2, 3, and specifically 3.
Sorry, 2. 82 lakh, 80 lakh, 3,000.
Now, my lord, while now, my lord, in the counter affidavit, when I refer to this paragraph, page 7 of the BDA, this portion was left.
Now, I'll come to that. What did you do with that money? Do you invested it any in the bank?
That has been kept in bank balance, not in fixed deposit. It kept in bank balance. In BDA,
so it earn the interest also.
Interest means less interest, of course, because it is in the.
That will be that argument he can say, not you.
I can say. I cannot.
If you say that, then he
I cannot say.
I'm sure
you will raise objection.
No.
That
I am raising.
I cannot raise that point.
No, you will raise automatically because he is the favored one. I know he is your child.
I am not. Why you are unnecessary?
Then unnecessary. That is my case.
Let us not blame.
Not you. Your claims.
Sir, not let us blame to anybody, but let us see about our case.
I might play game when I am aggrieved. I am not aggrieved at all. Right now, kindly allow both of you, please allow me to complete my submission. My lord, I will not interfere thereafter.
Judge also.
No, not judge, my lord, because can I proceed, my lord?
Yes.
The relevant paragraph of the counter affidavit that I was trying to draw attention of your lordship, my lord, which was left blank. Later on, it was filled up properly, my lord, in proper data that the bid of 4, 5, 6 newly pleaded opposite parties, my lord, as per the second.
1 second. See, when Suhasini got that other plot K426, what happened to the second bidder?
The second bidder?
No.
426, I never bid
for the second bidder, my lords. In case of that plot which is allotted to him,
426,
he cannot. he could not become successful, or declared unsuccessful, amount was refunded, EMD amount was refunded?
No, there was a second bidder.
No. He first bidder opted and then question of giving any option to the second bidder.
He opted because there he got, you compelled him to take that. Okay.
Which one? That is what. So she applied for 2 plots. One plot she quoted less and another plot she quoted higher. The higher plot would the amount he quoted in respect of that plot highest, which is between the two, if it is highest, then he is bound to take it. Then the second performance of the bidder will be treated as a first bidder.
Yes. The rationale behind taking the highest bid is that you should get more money
to secure the best possible price
of the public.
Yes, but that actually has happened.
But that will be defeated in his case.
That exactly means I will point out calculating this. Fact remains what has happened is, of course, my learned friend may complete the submission, thereafter I will say that.
Yes.
Let my learned friend say that yes, I'm interfering in his.
No, I'm grateful for my lord. Here, my lord, as per the second bidding, as per the information later on, my lord, brought to your lordship, kind notice, Sri Binod Bhushan Parija, 1 Parija, he stood the highest bidder
in the second action,
for which I admittedly I am the highest bidder. What they did, by applying their own mechanism, dehorsed the brochure guideline, they treated me out of their sweet will.
As the highest bidder for the first auction.
First auction, where let us ignore the size for the time being, my lord, for which I had bidded 72,72,000 as the auction price. In respect of the second bid, they are favoring somebody, Mr. Parija, who admittedly has quoted 80,03,000.
Less than any worse.
To the tune, my lord,
about 4 lakhs.
6 lakhs.
About
6 lakhs.
You are right. More than 6 lakhs.
And if we neutralize the entire sequence of events, my lord, that money was offered way back in 2023. If we go back to the static point of the case now.
But you had not deposited any money with them as of now, because there was no allotment.
The situation did not help me, my lord, to deposit the money. And I have been running from post to pillar, my lord. Please allow me to deposit the money, take the plot. And my bona fide is well proved because of the existing writ petition, my lord. And on last occasion,
you filed the writ petition when?
Immediately, my lord. It was in the year 2020.
Elastic word in English dictionary.
21, my lord. Exact date, my lord.
Filed on 21 February.
29/4/2021.
29/4/21.
And that time provisional allotment already.
Yes, provisional. But I became aggrieved because of this provisional allotment. And my lord,
you challenged the provisional allotment order.
I challenged also Annexure 6. That is the intimation to me. Second intimation, my lord, which was issued on 22/4/21, page 20, my lord. There the clarification came for the first time. There the point raised that
they say they cancel your second candidate.
How? Under which provision? That made me aggrieved. I came before for shelter of your lordship. Now, my lord,
they cannot do it. Is your contention?
Is my humble.
Unless law enables them.
So permits, man. So
let us come back after eating lunch, so that all will become more powerful than me.
Yes.
Yes. Appears to be a uphill task for you and for you also. Anyway, let us see. I don't know. You may have better points.
Pardon. Make a mention item 53, my lords. I am for opposite for petitioner. I have a specific matter at 2 p.m. I only pray if it will not be inconvenient to lordship a short accommodation.
Yes, sir. Whichever date you want.
No.
The first week of.
Otherwise, no. My
just because if I
only a short accommodation.
If I own in this case, I will only attend a job for 3 months to 4 months. That is my predicament, perhaps.
Let it reach, my lord. I am only praying, my lords, my lord.
Have it next week then.
My lords.
Call next week.
Grateful, lords.
At the request of one.
Grateful, lords.
Rajlochit Patnaik, may I seek for an adjournment?
49?
Yes, my lord. Item 49.
Anyway, I will adjourn it. No issue. Since my health is not good, I'm raising a little earlier. Yes, call this matter the second week of January. So at the request of inform the other side also.
Yes.
Yeah.
Item 42, my learned sister is there. She gives a judgment, my lord, that says that the judgment is covered. This case is covered by that judgment.
Covered by judgment.
But I will go through that.
You just go through and tomorrow
maybe taken up some other day so that
next week we'll have the week after next week. Have that?
Yes.
Week after next at the request.
Now, my lord, we had already discussed about the quantum offered by both the petitioners and the opposite parties. I am trying to proceed after that, my lord. I again repeat, my lord, Annexure 6 and its contention, which came to my knowledge for the first time upon its service on me, my lord. It was issued on 22/4/21, wherein I was informed, it may be mentioned here that since you have already been accepted in a selected bidder earlier, your candidature have been cancelled in respect of e-auction held on 25/3/21. This is the first intimation which made me aggrieved.
That is annexure?
Page 20, Annexure 6, my lord. Page 20.
Annexure 6.
My lord. Third paragraph of that letter, my lord. It may be mentioned here that since you have been accepted in a selected bidder earlier, your candidature have been cancelled.
That's the first time they say it is cancelled.
It is cancelled. Without affording any principle of natural justice, my lord, following any procedure of law, this cancellation was done. Let us, even if we assume that it has been cancelled. And this point I am raising for the first time, my lord. This alleged cancellation itself is bad on account of violation of principle of natural justice. In respect of auction held on 25/3/21, even assuming that law permits them to indulge in this, my lord, that I am prohibited to appear in subsequent auctions. There also you have to afford me a reasonable hearing, my lord, opportunity of hearing. In any case, my lord.
Where is that word cancelled?
Yes, third para. It may be mentioned here that since you have already been accepted in a selected bidder earlier, your candidature have been cancelled, held on 25/3/21. And you inform me after a month.
This is dated
22/4/21.
That's what you have challenged in the petition.
This became my order impugn. Yes, my lord, I can. Now, my lord, interestingly, from the very beginning, after the intervener was allowed to be opposite party number 3, 4, 5, 6, the consistent submission is that their money so deposited with BDA is lying there for last 5 years. They have deposited money, 80 lakhs is the emphasis being given by the opposite parties, my lord. I may pray your lordship, my lord, to refer to the first order of this honorable court while entertaining my writ application. What was the order passed, my lord? On 7/6/21. Admittedly, the writ was filed, my lord, on 29/4/21.
Yes. On 7-6, what the court said?
7-6-21, your lordship were pleased to interfere in the matter, issued notice to the opposite parties, and it is specifically mentioned since opposite party number state, one is the state, no copy is to be required to be served, notice be issued to the opposite party number 2 and 3 by registered post with AD, so and so. And in the interim application, my lord, 707, IA number 7078 of 2021, it is specifically mentioned, my lord.
If it is not already assigned, it shall not be assigned to anybody.
In the event the disputed plot under so and so the Bhubaneswar is not assigned to anybody, the same shall not be assigned. Since it is not assigned, my lord, then it was not assigned. So this was the development, and my lord, the ending portion is relevant because then COVID was in its peak, my lord. The parties may utilize a printout of the order available in the High Court's website at par with the certified copy, subject to attestation by the concerned advocate in the manner prescribed by court's order dated so and so so and so.
But by then it was already allotted.
Not allotted. In fact,
already. 8/5/2021 already.
In fact, it is a provisional allotment, my lord.
That's what. Noted.
When I said
it is provisional allotment. Provisional allotment was made on 12th April 2020.
This interim order is dated
7/6/21. And this intimation of provisional allotment is not in my knowledge, my lord. I was
allotment to OP3.
Let's wanted a question.
You keep me you give me a lot of entertainment.
And interesting part is we both actually gel well. So, and my lord may kindly see.
Provisional allocation dated.
That I don't know. My lord, that is
4/2021. 4/2021.
12/4.
Interestingly, my lord, in Annex of 6.
When he made the payment?
That will come, my lord. That is a story to be narrated by him. But allow me, my lord. It is interesting. It is interesting. Sit down. My lord, no. Already. That's what already was done, my lord. That is most interesting. Now this order is of, your lordship, as I pointed out, this order is of 7/6/2021. Opposite party number 456, they have filed one affidavit, counter affidavit, which I received on 5/5/25, as late as 5/5/25. Paragraph 7, page 4. In pursuance to letter under Annexure A/4, late Vinod Bhushan Parija, father of the present opposite party number 5 and 6, had deposited balance amount of rupees 72 lakhs after depositing the EMD, balance amount of 72 lakhs on 7/7/21, 8/7/21, 9/7/21.
After the interim order.
I understand his anxiety, my lord. Getting a piece of land, my lord, in the heart of the capital city is I will also indulge in this, had I have the money, my lord. I understand his anxiety. But I fail to understand the anxiety, my lord, shown by BDA. And it will be imperative to point out again, my lord, notice was issued on 7/6 when COVID was in its peak, my lord, that a person
amount deposited on
7/7 in 3 spells, 7/7/21, 8/7/21, 7/21,
8/7/21,
9/7/21.
8/7 is not there.
7, 8, and 9. In 3 consecutive dates. My lord. Now I understand his anxiety. He deposited. He was eager to deposit, and probably, my lord, I also. Exactly. That is what I was about. Probably he has no knowledge about what is happening behind his back, because he is a bona fide purchaser, my lord. He is a simple man. He doesn't know anything. He never influenced them. He only wanted to pay the money so that he secures the plot in view of the letter dated
12-4.
12-4, which was an intimation between the BDA and him. What is the conduct of BDA, my lord? And will your lordship ever believe?
When it was served on the BDA or interim order was served on BDA?
Exactly, my lord. The order was passed on 7/6. And COVID was in its peak. Certified copy in form of lawyer's attestation at least should have been served, my lord, within 15 days, because a person who secures a favorable order, my lord, his anxiety is just to ensure that
I want to know when it
that he can say
when it was served on.
Well, sir, we received notice on 28/6/2021.
Then why did you accept that money?
Well, money,
if you received that, why did you receive that money?
That's a parcel. My learned friend complete. I will submit that.
That will be better.
Otherwise, my
now, my lord, I am short of words actually. I use two harsh words, my lord. Collusion, nepotism, favoritism. I withdraw, my lord. I withdraw, my lord. May kindly supplement one good vocabulary, my lord, to supplement this.
It was served on?
Not served on. We received the copy of the read petition on the
registry.
The BDA received the BDA note, that is BDA 28/6/2021.
So I do not want to, my lord, unnecessarily to jump into, dwell into this. So the receipt of money was not in consonance to the spirit of the order passed. They should not have received at all. So the ground which is being taken.
Where that money was remitted?
To that video.
No, how? If the remittance section is different from litigation section.
Under one roof, my lord.
Of course, under one roof, billions of bacteria reside together. That is not the answer. What happens in one section of an establishment may not be known to the other section, but you are entitled to argue that effect.
No, I will not. No. I will meet my lord's what my lord is hinting at. My lord, the entire process is system operated. It is not open counters located at different places. System generated, my lord. If I effect the money, I have to again give a clear link to such and such auction. It will automatically open, my lord.
Once. How you came to know that this proceeding is pending?
They have been intimated. When I have approved the video authority to hand over the possession, they have been intimated by your lordship kindly annex, sir.
Where is that?
3/4, page 13 to my counter.
Where is
Yes, page 13.
What is the date of the author?
I have 29/3/2022.
29/3/2022. That was after your remittance of the amount.
Yes.
Till then you did not.
No.
And also there was a court order.
Yes.
There was a court order.
Yes.
Whether one knows or not, court order has got some.
Court order is there, but I will not.
That will be lispendence.
Yes.
Article, section.
Only I came to know at the instance of the BDA.
Very good. Then it will be lispendence.
It will be lispended. Now, I'll complete, my lord. So the money part is not there. Now, my lord, I come back to who is my lord senior also enlighten your lordship that I can so now we have arrived at a point, my lord, that the quantum I had offered, my lord, was 80,
much more than what
86 lakh somewhat, and the
he has 80 lakh 3,000.
3,000. So I will, to fortify my submission further, my lord, I rely on two decisions, my lord.
To the proposition?
Proposition that state being the authority, my lord, must ensure that the best possible price offered in an auction.
Counsel for the petitioner submits that state being the public enterprise, has to secure best of the prices when it disposes of the largest. What is the decision?
Government level. I start from Ramana Dayaram City.
One R.D. Shetty, R.D. Shetty versus International Airport Authority.
And if your lordship will permit me, one recent 2023 where Honorable Apex Court is of the view that, my lord, in an auction, para 24 of that judgment, my lord, the object of auction is to secure optimum realizable value.
Give that. This is what.
But my foundation would be
paragraph
24, my lord. 24, 25.
Go to next point.
So my offer, and one more thing, my lord, Annex 6 itself indicates my EMD value deposited with BDA. I quickly conclude, my lord. My EMD value deposited with BDA are still with them. So money wise, my monies are also with BDA.
How much?
For both EMDs only. No, I had given 5 lakh each.
No. 2 point, it is mentioned there. 2,27,200.
Quantum ballot?
Maybe 5.
Could be 5. And that is also lying with BD.
So what are your propositions? Number one is the highest price should be fetched.
To sum up now, my lord.
Not do. Number one. Number second proposition is
there was no provision to participate in any.
There was no prohibition.
As per their brochure condition.
For multiple participation in
multiple auctions. For multiple plots.
In multiple auctions.
For multiple plots.
For multiple plots.
For the first time under Annex 6.3.
What is the proposition acted upon in favor of Suhasini has to be practiced in respect of petitioner also.
Number 3, my lord.
3 over.
For the first time, Annex 6 was given to me, served on me, my lord, wherein I could know that my
Annex 6 is given, cancelling the candidature without opportunity. And despite cancellation, the amount deposited by the petitioner is not handed back.
Covers everything.
Yes.
Well, sir, before entering into all these things, may I point out 2 things. The amount which are paid to BDA, rightly pointed out that it is being, there is a, BDA has a connection with the bank. These are all either deposited in Chala directly, then account is given to the account section. Account section is different, is under one head.
BDA keeps the money, it parks the money in bank. So bank, it will earn the.
So but the fact remains, I took instruction, because my lords wanted to know that, I took instruction. This has been kept in savings bank account. It bears interest from the flexi and fixed account, what they say. It bears interest at the rate of 3, varies from 3 to 4%, in between 3 to 4%. That is what I instruction during that DCS minutes who have taken that instruction. But my humble contention is the petitioner. My first humble contention is that the petitioner initially applied for plots.
X-plot.
X-plot. But let us be very specific.
No, I have written them.
Yes, that is K1306, K41306. There he was the second highest bidder.
Second highest bidder. Suhasini being first. Suhasini withdrew from
Suhasini quoted
because she participated in another auction where she was the highest bidder.
Right,
money was more, and therefore you executed that.
Then
he became the second highest bidder. Therefore, he has to accept it.
So now question is,
where is that now?
I'm coming to that. Exactly, I want to point out that. Kind of class to annexure A/2 to my counter. Because pursuant to brochure you have acted upon. Now brochure is binding to you.
Let us see.
Page 15.
5.
Clause 6.8. To my counter,
annexure
A/2.
Page
15 clause 6.8.
Clause
6.8 would be relevant also 6.9 and 6.10.
Let us read.
Yes.
Successful bidder.
Successful. Married minutes. Married minutes. At the end of the forward action, media will decide upon the winner based on the highest bid placed for the property under e-auction and subsequent acceptance of BDA. The decision of BDA will be final and binding in this on all the bidders.
What it says?
They say that the people, though suppose somebody participated,
Highest bidder will be given.
The highest bidder will be given.
If beyond that, it does not say.
Subject to condition that if VDA takes other decision contrary, but that yes, they are not agreeable to pay that, but give that property to him, they also have that right to revise. But anyway, well, that power has not been exercised here, minutes. Then subparagraph 2.
No, in the event.
In the event. In the event. Well, just in the event. It applies here. In the event of one bidder quoting the highest bid for more than one asset and becomes H1 bidder for two or more assets at the closure of the auction.
1 second. What is meant by first sentence and second sentence?
In the event of one bidder
quoting the highest bid for more
than one asset. Why it is said, my lord? I'll have a glance to before that, I could have pointed out. One bidder
highest amount is quoted, that will becomes.
Why it is matters? I think there is a confusion because it is very difficult because the tender technical matters. That is why generally words are not coming to the tongue. But anyway, class to page 18, clause 8.13.
8.13. That is what?
An applicant.
It is also annexure A2.
See, the same process.
An applicant.
An applicant may apply for maximum 3 assets. In case the applicant becomes the successful bidder for more than one asset,
the successful bidder for more than one asset,
his or her bid
highest value concerning the
specific asset shall be treated as final and it shall be declared as a successful bidder in respect of the said asset only, and all other bids of the said asset that the part for the part I think deleted here, and the same.
What is meant by that? What does 8.13 mean?
That it says, suppose I am an applicant, there are number of assets. I can choose 3 of the assets in respect of which I can bid. I can participate in the auction. I can quote my value. But in course, it is found that yes, I quoted highest value in respect of asset number 1. And
the 8.13 is not auction specific.
No, it
is asset specific.
Asset specific. Asset have been mentioned.
One auction itself.
Yes.
You may put 3 assets.
More than that also.
Also.
Minimum 3.
He can apply for 3.
He can also. He had applied.
Yeah.
But that the whole total assets managed, there is a page, total asset under auction is at page 10. List of assets.
There are many assets.
There are many assets.
He applied for B39.
He applied for K4 1306. And another B39, I think that.
Correct. It's a different auction.
Yeah. So, just now, I'll kindly keep it in mind there. This is relating to Calling Nagar plotted development scheme. The scheme is divided into different sectors. K4, K3, K5, K6, like this. The Calling Nagar, so far as these assets are concerned, these are all 1, 2, 3, 4, 5. The 5 number of assets is for Calling Nagar concerned, were put into auction. They are also kind of glad to that K9A by 352. This was a bigger size plot available. Same project, same scheme, same project. K9A352.
Why you are showing it to me?
Must think is that then also bigger size plots are available. But you quoted K411411306, that is 1250. Then bigger plots are available. You have not opted for that. You have chosen to particular size of the plot and then quoted this bit.
No, 8.13
minutes
is not auction specific.
No, it is not auction specific.
It is
asset specific.
Asset specific.
In respect of,
but then how are you going to apply this?
My humble contention, I will, why I am submitting matters, kindly keep it in mind. I will come to later so that it will be required for my purpose matters. I will submit. Thing is that one can apply for 3 assets, but then all these 3 out of this
assets in one auction itself.
3 assets, but for that 3 bid document they have to submit. So they have to participate in respect of this e-auction process in respect of 3 assets also. But once it is found that he has become the highest bidder
in one auction,
in
respect of one or multiple
assets, then he quoted the asset he quoted higher will be taken as the asset allotted,
provided it is in one mono auction. Mono auction.
In the sense, minus mean that it is if it is
one auction.
One auction itself. It is
because
one.
The text of 8.13.
Yes, I keep it in my mind.
It does not use the word multiple auction at all.
No, it is not related. It is related to this auction only.
8.13.
8.13 is related to the auction conducted pursuant to the brochure minors. This is the brochure. I'm on there now. Fact remains here in this case, he applied for 2 assets or 1 asset, that is not material. He applied for an asset. He had selected 1 asset to put the bid before putting the bid, quoted the bid amount, and then the person concerned who quoted other bidders, those who have quoted was found to be H1, and the H1 was given. Then automatically, as for clause, then minor kind of glance to clause 6.8.
6.8.
Yes. That is page 15.
In the event of one bidder quoting the highest bid for more than one
assets, because it arises because of they have
option. Has a bid for more than one asset.
Here in this case, the 3 assets, but one is given option to participate in 3 respect of 3 assets. Minors have shown that clause.
He should bid the highest for more than one asset. For all the assets, he should be highest.
No, so in respect of the 3, suppose in respect of the 2 he has quoted the highest bid.
Correct.
Suppose I quoted highest bid in one respect of 1 plot, that is 1 crore. In respect of another 1 crore,
he has quoted only in respect of one site.
One. Which one, minors?
That was plot number K41306.
Here in this case, I'm telling about the principal minors. I'm not come to the petitioner now. So thing is that suppose a particular bidder applies for 3 assets, so they have liberty to apply for 3 assets, and he quoted highest value in respect of the 2 assets.
Why are you saying 2 assets? Only 1 asset?
No. He has quoted highest bid in respect of 2 assets. Highest value.
In respect of 2 auctions, you can say.
No, in respect of the auction held pursuant to this advertisement, this brochure.
In the very same.
Yes.
But he applied for only one site. 1 asset.
He applied for 1 asset.
Correct.
Now his contingency has not come. My humble contingency, the principle. The principle is that suppose somebody quotes
more than
1, and quoted highest in respect, become highest in respect to the 2, then the
highest amount will be
amongst the 2, the highest he quoted will be the allotted asset.
Correct.
And the rest of the second asset.
Then you go to rest of the
rest in the second bidder to come to the second bidder. That is what it is stated here.
But how this is applicable to the petitioner?
I'm coming. There, Well, he will be then only one asset. Well, I'm reading it again from the beginning. In the event of one bidder quoting the highest bid for more than one asset and becoming H1 bidder for two or more assets at the closure of the auction, he will be successful bidder for only one asset for which he has quoted the highest amount than the other bids.
Correct.
In case other assets of which the highest bid stood cancelled for the aforementioned reason.
Which is that reason?
The aforementioned region, in the sense the region quoting highest bid, one will get released. Amongst the two, you will choose one which he has quoted highest. The rest one, the second one is now released. Now this, in respect of the second one, what will happen? In case other assets of which the highest bid stood cancelled for the aforementioned region, in the sense one he has quoted highest, the other one is also quoted highest, but among the two quoted, he has quoted more than the other. That is why the second one was released. Now the second, in respect of the second one, the second highest bidder shall be the successful bidder. Am I clear, madam?
This is clear, but its application to facts of the case is not clear.
The thing is that the system is this: you are given an option to choose amongst the total assets 3 to bid. If you are bidding, then if you are quoting highest, you have become highest bidder in respect to 2 assets. Quoting highest will go to the person who has quoted highest. Then the second one will be released. The second one will go to the second bidder. Second highest, the second bidder quoting the highest. In this present case, that was the lady, what is the name? Suhasini participated in quoted bid in respect of 1306. Another is A4426.
In the very same auction.
426.
Yes.
Out of the two, it was found that the Suhasini quoted highest in respect of A4426. So she was given the second one. Now
second one of hers is cancelled.
Stood cancelled. Not cancelled, stood cancelled. Immediately one got brought, stood cancelled. Then the second bidder was the petitioner.
Where is that covered?
Well, the second bidder, well, the line matters. The second bidder, second highest bidder shall be the successful bidder. Shall be the successful bidder matters.
Come to class. However, the decision for acceptance of bid in respect of a particular asset will lie
with the BDA.
BDA.
In the above case, where there is significant difference between the H1 bid value and the value bid and that of the bid value selected by the selected. Suppose my lords H1 quoted very, suppose 1 crore, H2 quoted my lords 70. Then in such contingency, BDA enjoys the power to cancel, to stop it there and to cancel it. In this case, it has not happened. This condition has not been applied because the difference is very marginal. Only he quoted my lords, I must have given that number. Probably the Suhasini quoted 72, and the petitioner quoted only 20,000 less.
He quoted, petitioner quoted 72.72 lakh. No, you're speaking of first one. 72.72. 72.72.
Kindly be one minute.
That's what he said. I just written down what he has stated.
Kindly be, I got that information. Suhasini quoted my lord so far K41306 72.99.
No, he does not want it. It goes to the next.
No, I'm coming to that. Now he has been selected the highest bidder in respect of this plot.
And he also goes out.
Well,
he is not agreeable with that.
Question of agreeable or not, that is a different
No,
concept.
it goes to the next person.
It will go to the next person.
Yes.
That is the process it will go on.
Yes. But how can you deny that site?
I'm coming. That is in respect of the second bit. I'm coming to that. What is that clause? My lords, then my lord can kindly come to.
Explain to me.
Well, kindly come to my lords. My lords, kindly come to the clause, my lords.
Tell him to see me. Yeah. Now, how many bidders were there in this?
Bidders in the sense means it's a respect of a particular plot.
K41306.
Well, it's total bidders, number of total bidders. So I don't have that in.
That's very important. Otherwise, how are you going to operate this? You will not be able to operate that clause at all.
Because in between 1 and 2,
just ask them by phone. Ask them to immediately tell it.
And that I will get that.
If he withdraws, it goes to the next bidder. But how can you prevent him from taking the asset in another?
There is a restriction. There is a restriction.
Very good.
Also, I'm coming to that. Miller's clause 11.4.
11.4. If any applicant once selected as a successful bidder and his candidate is withdrawn or cancelled due to default, he or shall not be eligible to participate in any further scheme to be launched by bidding in future. But this is under the very same scheme.
Which one?
The second site.
No.
It is not in the new scheme.
No, under different schemes. Well, in the plots minors can be judged one thing. Under one scheme, number of in different sectors have been created. The K6, K7, in different sectors have been created, but the assets minors are different. That kindly compare that minors, that is with reference to
further scheme means what?
Any further scheme in the sense minors, suppose
whether these plots are in the same scheme.
Which plot minors? These
plots.
These are under the these are under the same scheme.
Then this clause is not applicable.
That exactly means what my lord says, my humble contention is this. Here in this case,
it does not read success. So if any applicant once selected as a successful bidder and his candidature is withdrawn or cancelled due to default, he shall not be eligible to participate in any auction. Is not the wording.
Kalinga plotted development scheme is the name and design of the scheme.
So same scheme.
I told that.
Another plot in the same scheme is not the wording.
Must kindly visualize one thing. Kindly have a glass to minors, page 16.
1/6 of?
No, my counsel.
Okay. So please read.
Then that itself says about the total plot under different schemes.
No, but that question may not arise unless you.
I also what my lord says on
the plots which he has applied for.
Yes,
we can go so that we will not be disturbed. The plots which he has applied for, they are in the same scheme.
Yes.
Well, we agree.
But these plot they applied for is under the Kalinganagar scheme, but in different sectors.
I'm not sector is not.
Well, let me understand that is under scheme.
Sector is not the word used in your
scheme. That is anyway, my lords, that is that whatever stated is stated. Well, I cannot develop into something because
it's not there.
Not there. But fact remains what they mean is, but what they understood is that once they made this provision for deliberately they made this provision that once you applied for a plot.
These are all statutory schemes.
No,
under some development BDA.
These are all schemes. The schemes plotted for these are not statutory schemes. Statutory means, my lords, here in this case, all these.
There is no law which establishes Bhubaneswar Development Authority. BDA.
Odisha Development Authority Act.
Act is there. Therefore, these are statutory schemes.
The schemes are developed by authority, so that is a separate bill. So suppose they acquire a portion of the land, then subdivide, make and they develop the scheme.
That 1980 Act. 82. You that Orissa Development Authority.
Development 1982. scheme, what I mean, what my humble submission is that, suppose let us understand Cuttack Development Authority or Bhubaneswar Development Authority, what is the matter? They have taken some area in government allotted and they have acquired some area through government and they developed a scheme like Kalinganagar Development Scheme. Earlier they developed another scheme, Chandrasekhar Development Scheme. All these schemes are developed as per the decision of the authority and the authority decides the modality and these modalities are developed in the brochure.
The authority acts under the act.
Authority is a creature under the act. Is a creature under the act.
And it functions under the act.
Under the act. And rule,
rules, regulations.
Rule is there. Rule says that the authority is to devise this allotment and the modalities of the allotment.
Therefore, they are statute.
Obviously. Matters on implication, it will be obviously by the statutory authority. Let us say in that way, it is by the statutory authority only. So my humble contention, here in this case, what happened? If minors will interpret in this way, that is a different thing, minors. But the thing what that they usually interpret is, you have been selected in respect of a plot, which you quoted and you got it, and thereafter you have been communicated that letter. One day before, of course, minors have noted that the particular date. One day you admitted that you have received one day before. Thereafter, you participated in the subsequent tendering process, subsequent bidding process, floated pursuant to another brochure. The second brochure is Annexure B by 2. Yeah. Annexure B by 2 minors. There minors, the whole total dispute is in connection with that page 28.
Before that, I'll ask. You cancelled his candidature by Annexure 6.
Annexure 6, my lord.
6. Yes, that word is there in the second paragraph.
Annexure 6. Okay. So let us understand what my lord actually in fact goes in my mind.
No, just to see that. Para 3. Your candidature has been cancelled in respect of the auction held on 25/3/21 by the empowered committee on allotment.
Annexure 6.
Page 20.
Before that, my lord, kind of last of page 16.
No, I'll come to that place. After cancelling the allotment, did you forfeit the amount?
Amount forfeited, my lord. But kindly read that.
No, I want to know. Did you forfeit that money?
That amount, that forfeited, man.
Forfeited. Where is the forfeiture?
Kindly, but that is before that, man. I am pointing out that letter itself. Kindly.
But however, you are eligible for refund of the initial AMD of so and so, deposited for the auction held on 25/3/21. Did you send that money back?
Then thereafter, taking note of the confusion arisen, it is once again reiterated that you have been accepted as a selected bidder in respect of plot number K41306, for which an amount of rupees 227 is due to you, that is a differential EMD. As an exception, you are once again given a chance to deposit the amount due to you in respect of plot number such within 7 days of the issue of the letter, failing which your candidature shall be cancelled and initial EMD shall be forfeited as per the. So here in this case, we have taken it.
Did you inform the forfeiture? Did you forfeit?
Automatically deemed forfeited.
Very deemed. It shall be forfeited.
That is in the brochure itself. Brochure itself. Forfeited. That is why the problem. Anyway, that is a forfeiture. That is now question comes. The petitioner applied for another plot under another auction. And he is floated through another auction process with due earnest manners. Things have happened in this way. While the auction period in respect of the first auction process was going on, this second brochure and second auction process commenced. So there got a lot of confusion in between the two. Some people, those who applied there, they understood whether they have been allotted or not. They didn't get any information that whether they have been selected as a highest bidder or not. Hospital or not? Now that is why the confusion arose, my lords. That I concede that to that extent I concede. But fact remains, the letter like itself, my lords, kindly have a glance to the letter itself in Annexure 16. Sorry, PS 16. It indicated that you have been selected and you know that before one day, of course it is one day before or on 24th you admitted that you have received this. You know that you have already been selected in respect of one plot, maybe one day before. Now you are again saying that you should be allotted that plot. This is subsequent plot allotted subsequent tender process. To that you have given your reply. And after that reply, the authority considered leniently, because of the confusion, wanted to give an option. Yes, you can avail that plot. Deposit the money, you can avail that plot.
So the smaller one.
Smaller one. Dispute arose not because of this. Smaller, one plot is smaller and bigger. The other, because bigger plots were there, you could have applied them. Bigger plots. You have never opted for bigger plots, or you have not participated in the sort of bigger plot. You participated in the sort of the smaller plot. Minus, I got that in calculation quantified per square feet to show why it has happened, why it is happening. Minus, kindly visualize one thing. The plot size is 1250.
1250.
1250.
Yes.
That K1306. He quoted 72,72,000.
Yes.
Per square feet will be 5,817.
37 square feet it is.
Means? The second one.
This first one.
I'm telling about the first one.
1250.
You quoted at the rate of 5,817
per foot.
Per square feet. Now in respect to the second plot, it is a bigger one. You will enjoy bigger size. You quoted amount 4,053 per square feet. So question is, if this should be compared, then if you will get the second plot in a lesser price, you will get that. You will get that in a lesser price. And secondly,
lesser price for lesser amount. Price is higher.
Well,
price is higher.
Price no. So it is 5,817 per square feet in respect of the earlier one.
So price is higher.
Earlier one is higher.
Yes.
The subsequent auction, the suction bid amount quoted, multi-bid quoted, it is lesser.
Correct.
It is lesser. So he gets it in lesser price and bigger plot. A lesser price and a bigger plot. Consequently, what is happening, my lords? Suppose this price minus whatever this price, we will convert it to, my lords, multiplying it. Then, my lords, the BDA, first of all, the principle, BDA to add out to the principle what they have followed and they have adopted, one part. Then second, my lords, the BDA is now allotting it to 80 lakhs. The third person, he is quoted 86 lakhs. Now question is that if you take this plot at a 5,000 some odd square feet and 80, adding both would be beneficial to BD. But thing is that I should fairly concede. Thing is that you quoted less price than the price quoted earlier.
No. Now, what happened to that K41306?
That is there.
It is still there.
But my lord, so interim order is there, no?
Interim order is in respect of what?
In respect of this subsequent plot. But fact remains, kindly visualize one thing. That is what the authority they were required. I told them, right or wrong, means one plot was allotted to him. Suppose the Honorable Court have come up with a plea that yes, he will be entitled to that plot. By that time, you will be auctioning that plot. No plot will be available. It would create inconvenience. It would cause.
I'm just thinking. I'm thinking aloud.
Let us have conciliation.
No, as between you.
Yes.
If an auction is now put.
Yes.
I'm just saying that. I have to decide the matter on merits. I'll decide another thing.
Just on the probability side.
Probability. Suppose as between only you. If auction is put here itself in the court.
Yes.
Are you agreeable for the proposal?
I can years back. I can.
No, they have.
So therefore, now
that amount will be taken care of.
You perhaps you have no defense at all because you are claiming under him.
Yes, my lord. Already
You are the next
as per their direction
in the chain.
I have deposited everything, and as per the non-grant conditions, I have
Done.
There is a notice put on.
As between you two. Now, suppose if the court proposes an auction, many options are available to the court. In the idea of justice by Amartya Sen, he says how to resolve a particular dispute. That technique I'm thinking of pressing it to service. Now, his contention is the BDA should not get loss at all. That is his submission. Is it not? You submitted that BDA
66 lakhs rupees.
You cited two decisions. The BDA should get highest amount.
Being state, my lord.
Yes. Is it not? Now, taking your proposition little higher level, elevating it to the higher level. Now, on the basis of those decisions, to put silence your one argument, we will now put the matter to auction.
Bench value should be?
Here only. Here only. That will be the envelope of auction. Or it will be conducted the bid. I'll ask my court officer to raise the bids. Are you agreeable? Because those who do not agree, then that will be one of the factors for deciding the remuneration. You ask your client over phone and tell me. Otherwise, leave it to me. Whatever I decide, I decide. Number one. In the event he does not agree for auction, is your client ready to pay higher amount?
To meet what? On account of the projected loss being...
Not only that. When public property is involved, court is also a stakeholder.
My lord, absolutely.
Though judge is not.
No. Court is guardian of everything. Language court is guardian of.
Therefore, court has to ensure that the profit accrues to the other side, to the government. And we will also be taking...
May not be profit, but reasonable best price.
That's all. I am telling. Now, that reasonable best price will be today. Today.
And the best price, I believe, my lord, with my rudimentary knowledge, is 86 lakhs some odd thousand. That is the best.
Okay.
So now the question is...
Base price.
Because that was the best price.
At that. Today, we are on the proposition. Today, that happened during COVID period. COVID period is treated by all jurisdictions on the globe as a special circumstance.
Absolutely.
Now that circumstance is not there. We are in normal circumstances. Still another COVID hits. Let it not hit us.
Let it not hit us.
Now we are asking you, as between you two, if the court auctions, do you agree for this proposal? If you do not agree, that will be one minus point in your account while deciding that. Because conduct of the party is also important to the jurisdiction.
Now, I will eagerly say yes, because
I visualize it. I'm saying 2021.
You have deposited.
I have deposited 8 lakhs. Now, if interest 6% interest, it will be 30,000.
If suppose 6% interest is given back by him to you, will you receive that?
No, then I have to take this.
For everything you are saying no.
But take instruction.
No, then again I will not adjourn. You just ask, go and ask. Call here
outside for 5 minutes.
Why outside? Call here only. Call your client. Give him a phone.
My lord, can I take your just to make a call so that after 5 minutes?
Very well. Afterwards, no problem.
So because they are staying at Koraput. So
Koraput makes no difference.
If possible, I will get
in Moscow.
If not possible, lordship, 7 days time may be given or 3 days time may be, so that
you want to send a postman from here?
No, my lord.
Yes, call him over phone.
It will not possible.
Very simple.
Let me contact today, my lord.
Why? You can't say that. He should say. Now call him in front of me. What he will say, look at you. You can't say that your client is not wiser. Call him over phone here. But don't instruct him that do like this. Therefore, I am asking you to call him here only. This is one technique. In fact, in idea of justice by Amartya Sen, he gives so many techniques as to how dispute should be resolved. And court being a stakeholder, that aspect he has not considered in his that book. It's a good book. He writes it in distinction to John Rawls' theory of justice. He was a student of John Rawls also.
May I go outside?
Yes. I tell him that court will not be waiting. He has to take a decision instantly. After all, it's a public property. Your people also have created mess.
Sometimes it's better to remain silent than to speak something more than record.
Now ascertain from your client what is the present market price.
I ascertain.
You have ascertained what is the present market? 1 crore.
More than 1 crore.
More than 1 crore.
I also found that the price suppose was 2,317 square feet.
More than 1 crore means what is that? Up to what?
No, it would be, I calculated it, it would be 1 crore. 1 crore. Yes, it will 1 crore 24 lakhs. 1 crore 24 lakhs.
1 crore 24 lakhs. Yes, sir. What does your client?
I have part of the informational. I will receive information.
Okay.
Still, I'm trying to get an input of the plan. Again, I had 3 apartments.
Yes, sir. Nice. The phone rings, do not disturb me. Because I have seen the telephone phone of one Chief Justice in Karnataka High Court ringing when he was on the bench. He was very strict with all the lawyers. Whenever the phones used to ring, accidentally they'd ring also, like church bells. Why we should get so much disturbed by that if we are involved in the job? Unless it is extremely disturbing, etc. Then from that day onwards, he relaxed that rule. If even when phones were ringing, he would not take any action against any of the lawyers. No. I will start dictation now. In the meanwhile, you can have the input from your client. Right.
The scheme, the statutory scheme.
Statutory. It is bound to be the 2006 Supreme Court. Whenever there is any scheme drawn under the statutes for allotment of the public property or public lodges, it shall be deemed to be statutory. Section. The very act itself says this. We have similar act of 1987. Karnataka Urban Development Authorities Act 1987. Or 82 Act. Start. I will not give hint as to what I am going to do. Yes.
Everything will be on phone.
Yes. Everything will be enigmatic. Yeah. Petitioner is knocking at the doors of Big Court. Go to plain column. For assailing letter stated 23/3/2021 and 22/4/2021, respectively at annexes 4 and 6, issued by who had issued choking. OP numbers 2 and 3. to the collective effect that his candidature in respect of auction dated 10/3/2021 comprising plot number K bar 4 by 1306, edge measuring 1250 square feet, having been cancelled, comma, he would not get plot number K-5 of 477, edge measuring 2037 SFT, comprised in the auction held on 25/3/2021. First E. Next paragraph. Learned counsel for the petitioner, in support of the petition prayer, vehemently canvass the following propositions. 1. There is no restriction for participating in any number of auctions, although there is one, while fructifying the same in respect of particular plot, object being distributive justice contemplated under Articles 39B and C, small 39B and small b and C. Petitioner being the second highest bidder in respect of auction dated 10/3/2021, she had also participated in the auction dated 25/3/2021, wherein he figured as first bidder, highest bidder. Therefore, consistent with the proposition that the disposal of public property should fetch more wealth to the exchequer, his bid in the second auction ought to have been accepted, and the allotment of the bigger property, larger property, ought to have been paid. Third, the conduct of OP numbers 2 and 3 is short of fairness standards, in as much as it has demonstrably favored the claim of another private bidder whose LRs are made OP numbers 4, 5, and 6 to the petition by way of intervention application. First off, he points out petitioner's highest bid amount in respect of auction dated 25/3/2021 was rupees 86.63 lakh, whereas the amount for which the subject property has been allocated to OP numbers 456 is 80 lakh 3,000. He also points out that next point. Council also points out the conduct of OP numbers 2 and 3 in accepting the remittance of remainder of the auction amount by the OP numbers 4, 5, 6, when there was a interim order granted by a coordinate judge of this court on 7/6/2021. Come on, especially when the said order was served on 3 and 4 on 28/6/2021. First off. Lastly, the entire process at the hands of OP numbers 2 and 3 is replete with multiple infirmities to the detrimental of public interest in general and to the private interest of his client, and therefore relief should be accorded to his client. Next point. You went outside for calling your clients. Yes.
He is not interested for an option because he already
has remitted the money. Even when he is not ready, are you ready to make higher payment?
My lord, it was not a discussion. I told him categorically,
yes,
on account of your interference by way of filing this writ petition, whatever pecuniary disadvantage is being caused to the BDA in whatever form, you have to compensate.
No, what he said is important.
Yes.
He said yes to that.
Yes.
According to you, what would be the...
My lord, I have to. I'm just proposing, my lord. I'm not sticking to any of my.
Just proposal. I may consider them.
Yes, my lord.
Framing the
discard. Yes, I have quoted. First of all, my lord, his money deposited with BDA is
same.
No, rupees 80 lakhs
3,000.
80 lakhs 3,000. Interest accrued thereon is to be now refunded by BDA, including the principal amount. First proposition is whatever interest.
That is 3%. That does not attract that.
It is not saving bank. Saving bank with flexi account. More than 10,000 receives FD percentage.
Correct. It's a flexi deposit.
Flexi deposit.
But
More than 10,000.
Interest is not more.
Whatever for 4 years, I will compensate. One. Second.
No, that you are compensating to him. It is not compensating to them also.
Second, one. I will explore all possible. Second is, I had quoted 86 lakhs 63,000. That would have been with the treasury of BDA. Let us assume
with you.
I kept that with me. Admittedly.
No, I assume you are with you. It is with you.
Admittedly, out of which 5 lakh is remaining with them. I would have not deposited had my application approved. 86 lakh 63,000 minus 5 lakhs, which still they are enjoying with interest, my lord, is 81,63,000 some odd. I'm willing to pay 4 years interest on it. That will be 12.
Now just see the guideline value. Guideline value it is not market value.
Guideline. That quoted, but that value quoted within the
1 crore.
That I
59 lakh.
Please show me that.
No.
And my lord, one more thing. I also will bow down, my lord, to the proposition. In case if
I'm asking you, I am not proposing.
No, I am asking. Since I have got the authority, my lord, to enlighten my lords. In case BDA files any affidavit that this much of amount, if he pays, whatever amount, he is also willing to match that.
Not BDA. You tell the court now. Once we send it to BDA, again, now begins.
Now let us assume
Lordship, my client has said that since I have deputed, whatever order passed by the honorable, I will
be acceptable to him, subject to right of appeal.
Yes,
that's all.
My lord, let us assume I was due to pay 4 years back 81,63,000. I need to calculate 6% interest, highest interest applicable.
Why 6% in the bank interest? I am getting more than 12%.
More than
12%.
Which bank?
Many banks.
Not
HDFC Bank.
12%.
11.68%.
Oh, you are 60 plus. But still then you
What is the age of your client?
Very young.
Very young. It is his mistake.
It is his misfortune. Actually, it is his
big form later.
12%, my lord, is
11.68%. Anyway, this is a commercial transaction. There is a.
I'm not here to make any.
I'm asking you. You are already owning one house. Your client is owning one house.
No house.
Ask him.
No house. But telling you also.
No house.
No house.
He is a houseless man.
No, he is on rent.
Is he an income tax payer?
Absolutely. And he will pay from his account, not from father's money, relatives' money, my lord. That instruction I have received just now.
Well, now what will be the guideline value?
Well, whatever my lords will decide, I talk.
No, guideline value. You have to decide me.
Guideline in the sense, my lords.
Ask the sub-registrar. What is your
benchmark valuation? I told him that the officer has gone to this land section to get that benchmark valuation. The market valuation. Market valuation is much more than the benchmark valuation. The market valuation, what they found is, it will be more than 5,500 per square foot.
5,500 per square foot.
That is market value.
That is the speculative market value.
Benchmark valuation. Benchmark value less.
So I'm open-minded, my lord. So far, compensating BDA is concerned. In addition to my quoted value. Whatever amount my lord will find just.
You just give one small chit to the learned council. You tell what I may not accept at all.
To give an.
I am not recording it.
No, it's a chit.
It's a chit. Don't show it to anybody. You turn the other side or close your eyes.
I'll go outside.
Yeah, very well.
So that I can close.
You can't have public property for a song.
What is the fault of the present petition?
No fault at all. Therefore, we will recompensate you.
That is not the issue, my lord.
Why?
They have incurred the.
You mean to say the BDA should incur the loss because of their mistake? You will get back your money. You will get back your interest. Maybe little solatium. How do you agree?
We are the beneficiary. Fault of the BDA authority will suffer or not?
Well, you
for last 4 years we are waiting for that.
Land will be. You remitted the money when there was an order, though it was not served on.
No, my lord. That they have intimated that you deposit the amount accordingly.
Therefore, I will ask them to make payment to you. Some amount will be paid to you.
That is not this because we have deposited money for the piece of land.
Then
And
for
if
that
that will
will
constructed
no
by
piece of earth you can get for a song. No piece of earth you can get for a song. That's a it's a very upcoming area. Therefore, we have to balance. Therefore, we are protectors of the public property also, public exchequer, and the largesse. We are participatory role now, not adjudicatory. Adjudicatory, in addition to that, participatory.
With regard to auction, but he is ready to pay whatever auction amount was the suppose
we gave you 3 options. Number 1, you take back more money with interest and say goodbye, to which you are not agreeable. We said we will hold the auction as between you and him, and we will resolve the dispute. For that you are not agreeable.
At present,
then we asked you whether you are ready to enhance the money which you will pay for this site. You are not agreeable, apart from auction. All the 3. For all the 3, he is agreeable. And you will be compensated. There is nothing, one English judge said, there is no legal injury which cannot be compensated in terms of money. Long ago, more than a century ago.
Problem is that
money is the panacea.
Problem is that details I have not made in discussion, my lord. So that is why I put 3 days time given that so that it will be very easier.
I have spent a lot of money on this because I want to lay down the guidelines. Therefore, I have spent a lot of money.
Already certain this decision has been taken by your lordship. So we are not ready for them because since we have already completed everything as per the direction of the BDA authority, we have hope that
BDA is at fault now.
Yes.
Therefore, that fault will catch to start on you. Though there is no fault on your part, you are claiming under the BDA.
Yes.
Therefore, it is 52. The BDA ought not to have accepted your money in the light of the interim order.
Prior to filing the review application, they have already given the letter to
that was provisional.
Accordingly, we have
that was provisional. That was interdicted by the court, by the coordinate bench. Any other points you want to argue?
I have to take only a second for the for the technical discussion.
Hearing so much, I will not plan time.
No, lordship, asking.
Yes.
Present day speculative market price is taken into account, which is distinctively higher than the amount I had bidded. And considering that, my lord also take kindly should take note of the fact that my 5 lakhs are is with BD.
25 lakhs. His 80 lakhs are here.
Exactly. And that is not the fact. I will bow down as I stated to your lordship.
According to you, how much it is?
They say that actual market value is not ascertainable, but it will be more than more than 1 crore 15 to 25 lakhs.
One crore 25 lakhs.
It will be, they said, ascertaining from persons, 1 crore 25 lakhs.
You said 5,500.
So
5,500 if speculative market price. Not the calculation I
got that information from our official staff The market value is generally not available. It's going in a market. They ascertain that it would be more than one. That would be above 1.25. They categorically stated it will be more than 1.24.
If 1.25 is given, now that 80 lakhs plus interest you have to pay back.
Whatever interest accrued in addition to that.
Yes. Whether your client is ready to pay.
He has deposited the amount money for a piece of land.
I have answered that.
So
I repeat again, no piece of land is available for a song.
No, my lord, I have pitched. Whatever amount is benchmark valuation, whatever it will be, you have to insist my client to deposit that benchmark valuation.
We will consider your submission also. You pay 1 point, you file an affidavit, the memo now on the instructions of your client that you will be paying 1 crore 1.25 lakh. 1.25 lakh. This is a proposal. If you agree,
no, please proceed.
1.25 lakh, then 10 lakhs to him. So that even if, you may not agree. He will deposit here. If you take well and good, if otherwise it will go back to the BDA itself.
1.35.
1.35 in all. I will give you some time to you. 1.35. Out of that, 1.25 will go to them. He will get his 80 lakhs plus interest accruing therefrom. 10 lakhs he will get from you so that his appeal will not be entertained. Hopefully. Otherwise, you run the risk.
Then I need to find, because my lord,
now this will be the court order.
Yes, 1.25 itself is speculative price, which is not the price. Neither the market value, the calculation according to him 5,500.
5,000? You know that market value I collected from
in Bhubaneswar, my lord. Yeah, to be very honest.
Bhubaneswar is next to Bangalore now.
No, my Bhubaneswar.
Much more than Bangalore.
More than.
It is almost at par with Bombay.
Bhubaneswar, that
goes against your argument.
I should be honest, my lord. Why should I?
I should appreciate.
I should be very honest.
I have seen him.
And the reason that he cannot go to the open market, that is why they both participated in auction bidding.
He also cannot go with a heartburn. His case is, I wanted a piece of land, therefore I did not want my money back.
No.
Therefore, I have to make some provision.
Some little scope, my lord.
No. This is very, very on the lesser point actually.
Pass that order, my lord.
Over. You file memo.
I'm filing it.
That I will make a point.
And my amount will be 1.25 to BDA and 10 lakh as compensation to.
Not compensation. It is a solution. Because you are not at fault. Therefore, I am saying solution.
My lord.
But solution is to give him solace.
To give him some solace.
And money that they should give to the truth so that you will get the plot. He will have interest with the money plus 10 lakhs with you. 5 lakhs from your side. 15 lakhs he will have. Out of 1.25 which he is giving, 1.2 you will retain instead of 80.
Right, man.
That will be 40 lakhs more than that. Therefore, because of your fault, you should pay 5 lakhs from your pocket.
Right, man.
Yes.
So, may I submit?
Yes.
Whatever market value, as per the benchmark valuation, during that time. So, my client is agreeable to pay.
Whatever is market value.
Market, as per the benchmark values.
No.
Benchmark valuation?
No. Now they have said, therefore I told you, stand to auction now. Within 3 minutes, matter will be over.
Possible if not present here, but
then it's not possible.
Not be possible.
No, not possible. Then not possible. You file, brother, you file.
I'm filing a memo right now.
Right. Yes. Having heard learned counsel for the parties and having perused the petition papers, come on. This petition is favored for the following reasons. The court has put the proposal to private parties to the petition to go for auction, intersect, between them intersect, and private OPs refuse to refuse it to accede. First. However, petitioner came forward with a proposal that he would pay about 40% extra money. How much it will be? 186 it was. 46 of 80. 80 he has paid. Now he is paying 45 to you. That will be more than 50%. More than 50% of the bid value of the private OPs. And he rounded it off to 1.25 crore. First up. He has shown further fairness by offering to pay a lump sum of rupees 10 lakh to OP numbers 456. Since they wanted a piece of the land which they could not get, eventually the same being allotted to the petitioner. First up. Justice is done to OP of the private OPs in as much as they will get back their 80 lakh rupees along with all the interest accruing due thereon.
In the flexi and
whatever. In as much as the same has been parked by the BDA in a flexi deposit account. Flexi deposit, that's called flexi deposit account. First up. This apart, the BDA, out of the amount payable by the petitioner shall pay another sum of rupees 5 lakh to the private OPs. Private OPs. First. Next one. The contention of counsel for the submission of counsel for the petitioner that merely because the highest bidder in the auction dated 10/3/2021 went for another property in at another auction would not relegate him to the level of first bidder, first highest bidder, in such a way that he would lose the status of highest bidder in the second auction dated 25/3/2021 in respect of a larger property has got lot of force. First, it has been the settled position of law that the public largesse on disposal should fetch highest market value. First, some of the clauses which learned panel counsel have given for the BDA pressed into service, more particularly clauses 6.8, 6.9, 8.13 and 11.4 ought to be construed in a purposive way in the light of all other terms and conditions in Annexure A2. First, it needs to be stated that the tender conditions cannot be construed keeping the common sense in cold storage, nor contrary to the grand norms which the apex court has laid down. Can be seated, sir, in a curtain of decisions from R.D. Shetty to 2023, which was mentioned here. Next paragraph. The vehement submission of learned counsel for the OP numbers 456, that his clients had deposited the money with the BDA, remitted the money with the BDA in a sum of rupees 80,03,000, was with intent to secure a piece of work and not for getting it back, with interest accruing due thereon. Come on, he is only a half dog. First one can secure public property only in a normative process. First one, there was an interim order by the coordinate judge handed on 7/6/2021, in the light of which the BDA ought not to have accepted the remittance made by the said OPs on 7/7/2021, 8/7/2021 and 9/7/2021, when the said interim order was served on the BDA well in advance, that is, admittedly on 28/6/2021. The writ court has to ensure justice in the light of competing claims, competing equities. First, no prejudice would be caused to the private OPs since they are getting the money back with interest plus rupees 10 lakh by way of solatium payable by the petitioner plus rupees 5 lakh by way of costs payable by the BDA. First, in the fitness of the things, the BDA should not be put to any loss. And it is not being put to by this judgment either. In as much as the petitioner has filed a memo agreeing to buy the property at a price of rupees 1,25 lakh, which is more than 40% of what the private OPs had wanted to buy it for. It should be little differently worded. The express is there now. What you can do is offer to, not deposit, offer to pay. It is pay, not deposit. Number one. Secondly, the figures are high. Therefore, mention them in words. In words. Word sounds. Okay? The memo filed by the petitioner reads as under. Next, in the above circumstances, this petition succeeds. A writ of certiorari issues quashing the imputed debtors. A writ of mandamus issues to OP numbers 2 and 3 to allot plot number K-5/477 at measuring 2037 square feet, comprised in the auction held on 25/3/2021, subject to all other compliance, usual compliances, within a period of 8 weeks you have to do.
He will deposit thereafter balance 4 weeks.
And the conveyance shall be executed and registered within 4 weeks following the same.
Let him comply all.
That's what I have said, compliances.
And all these calculations, my lord, are in addition to the 5 lakhs remaining with them, or I will get some.
No, because 5 lakhs they are giving to him, na. From that money they are paying that.
So I am paying for his money. My 5 lakhs towards him.
5 lakhs. That is the reason.
So effectively,
I did not say. Effectively, that will be 1.30 you will be paying to them. That 5 also will go
to him.
To him.
So finally, I would be paying 1.30.
1.30 plus 10 to him.
No.
Yes. 1.25 I had agreed.
To him. 10 to him.
10 to 1.35.
So
the
1.35.
amount which you have paid to them will remain with them only. From them, that they are paying 5.
So he will get 15.
15. Otherwise, he will not get justice at all.
Okay.
You add one sentence there only.
No, I will not.
The amount which the petitioner has already remitted in respect of 2 auctions shall be lying with the OP numbers 2 and 3, who is made to pay cost to the OP numbers 4, 5, 6. Within what period you are paying within what period? See, the 3 months I have fixed now. 8 weeks for formalizing the allotment, then 4 weeks for executing the conveyance, registration of the conveyance also. That will be from the date you make payment, remit that money.
My lord may give some breathing scope to effect the payment.
Very well. You tell whichever what I will give you.
2.5 months, my lord.
3 months will.
3 months.
3 months. First one, 3 months. For the petitioner to make the rest of the payment. The 10 lakhs, immediately you pay that. You deposit the 10 lakhs here. I will permit him to withdraw.
Here means with registry, man.
With the registry of this court. Petitioner to deposit rupees 10 lakh payable to the private OPs. And private OPs may withdraw the same in terms of this order from at the hands of the registry within 8 weeks. First, in the event that amount is not withdrawn, the same shall go to the BDA itself.
So for minors, amount lying with BDA, I will ensure to pay it minors with interest and all these things, calculating it within.
Yes, entirely you have to pay. Both with the BDA to pay back. It's already there, entire amount to the private OPs along with the interest. We have already said that. This way, the judgment will be little linguistic modification it would undergo, because at the spur of the moment I have decided these things. All right. Okay. You are more than fair to the court. You are really more than fair to everybody. You made very strong submissions and was very strong on law and very fair and reasonable. Send it to you. Yes, ma'am. I am not taking any matter. My health is not good. Therefore, do not rush to the well of the court. I have difficulty.
I know.
My health is not well.
May I request for item 37? Last okay, the Lordship fixed at 2 o'clock. Today it has not been fixed at 2 o'clock. Any date convenient to Lordship at least.
Yeah. One week I will not be there.
My lord.
1 week I will not be there. Next week I will not be there. I will be back on 8th. Therefore, for other judges, I will fix it. Let that go.
My lord,
this could also.
My lord, my matter may be. My lord, my matter may be taken. Please. My lord.
On 17th we will have it.
At 2 o'clock.
My lord.
At 2 p.m. That day, see, whenever 2 o'clock is given, you have to put the number of cases.
My lord.
Okay, urgent questions.
Only item number 42.
My lord, my matter may be taken.
All them to file the vacancy position. Out of 17 years of practice, I was terminated.
Vacancy position, you were asked, what has happened?
He was there. Last 2 times, he was not there. That's why he wrote to deposit. At least, this year, he can get the job.
This year, it is difficulty. In the first week of January 2023.
Lords,
yes.
41. Your Lordship that fixed it today.
Yes, sir.
So,
I did not know when I fixed the date that bacteria will attack me.
Lords, January, my lords?
January. Third week of January? Third. Any interim order is there? No interim order.
My lord, 43. My lord. Similar cases may be listed with 43, my lord. 1079 of 25, 31941 of 24, 11424 of 24. Similar matter, my lord.
43?
Yes, my lord.
You list yes, tell that. You just tell it from collector, from the lawyer. You give the list to court officer, he will do that.
My lord.
Any other?
My lord, this is the appointment matter, my lord. I pray for early list.
In the second week of January.
Okay. Okay. Can I take? Can I return my payment? Second week or third week of December?
No, not.
My lord. My lord.
Sir, your matter will put to the first week of January. Some date you choose. Take date choose low from the calendar. Calendar say.
There is some
audio problem. Or he is not catching my language.
Yes.
Somebody can you
आपका जनवरी तारीख को कौन सप्ताह जनवरी सप्ताह कौन सी तारीख को कौन दिन 15 केस
My matter listed wide 52 number, my lord, item. So I am not getting 17 months salary. Matter is very simple. My grievance is very simple. In absence of exercising OCA CCA 1962 by the OP number 4, DO Gajapati Parlakhemdi, the DO headmaster, all are playing with me. It is foul play. Further, my lord, my case is squarely applicable to S. Bujibabu Sharma and versus High Court of Orissa.
In person. He is in person.
52 is in person.
In person. Name is not there. He is in person.
I am placing 51 units.
51.
Finance. The business circuit was there, but it was posted to today because to cite some judgments only.
Yes.
Transfer matter. And the Honorable Court this one held in several matters for transfer is not applicable to this type of employees. Yeah, payment is sorted.
So we'll have it in the third week of December. You will that matter. So we'll take in some
second week.
My lord, item 56, my lord. Item 57, my lord.
Any urgency?
My lord. My interim age of 80 years old Rita teacher, they are not getting the
January.
My phone.
The part matter.
That will come before only in the second week of January. We will have that.
Item 56, my lord.
No, he's saying that.
The pre-order there, my lord, that may continue, my lord.
Because of the fact that still we are risking the inconvenience, all the
Inconvenience, everything. No, Mr. The court commissioners went and they have.
I'm with heavy heart. I have given my objection with heavy heart. I'm not supposed to castigate or do anything. How the commissioner could get a OMIN from BTA without requisition? And in spite of the secretary's order.
But commissioners have got all their hands of the courts. What can you say?
That is not, it's a different matter. It's a different matter.
Where two ladies.
Twice it has been found that.
Let us see anyway.
And he says that I have done unauthorized construction.
Second week of January 2026.
Pre-model may continue.
Very well in all other matters.
And twice the information order has come out, my lord. Fighting for that.
Let us.
My item number
all are
56, my lord, interim application is pending. Lordship had issued notice. They have appeared, my interim application to be considered, my lord.
Interim application for?
For stay of, my lord, they have issued a fresh, my lord, rate chart with regard to my vehicles have been engaged for carrying milk, my lord, from Hon'Ble, my lord.
Where the driver, there was some allegation against.
No.
Not that case. Not
Here, there is a valid agreement. The agreement is subsisting. My agreement is subsisting, my lord. They have now revised the rates. That is why I have come before you. Lordship,
that revision of rate is not applicable if they discharge their part of performance fully. My lord, allow me please. A 100-liter container should carry 100 liter, my lord, for transportation. It cannot conveniently carry 20 liters. That is the clock, my lord. Kindly allow me some time, my lord, reasonable to file my counter. Thereafter,
because they are now
18th of December. 18th of December. Yes, you wanted to say something.
Yes, I will just pass on this memo, my lord.
एक केस 40 नंबर जो डाल दिया
because I repeated because of my deposit, I clarified my lord pay.
Which is that you have given? Other one you have.
Other one also.
You again said deposited only.
I stroke pay.
No, that is perhaps.
No,
Stroke pay is not here.
No, that is there. This is the first one where I mentioned deposit. The second one, I again repeated because of my flow of hand, my lord.
No problem.
Mentioned deposit, but stroke pay. I have
this one.
No, second one, my lord.
No, this is second one. No?
Sorry.
Second one. Okay. Nice.
My lord, 54.
This also both.
My lord, 54, my lord. I am unemployed, my lord. I have challenged the...
Which year?
My lord, this year, my lord. Honorable Court, my lord, they are not file any counter, my lord, till that.
In the call in the second week of January. In the meanwhile, counter, if any, may be filed.